Bonjour mesdames, bonjour messieurs, à la fois ceux qui sont présents et ceux qui sont en ligne. Bienvenue dans cette conférence sur l'intelligence artificielle générative et les professionnels du droit. Nous sommes très heureux de vous accueillir. Le réseau Lexing est aujourd'hui dans la plupart des continents. Plus de 42 pays aujourd'hui représentés, et pour la plupart ils sont venus de très loin et ils sont présents. Et merci à ceux de l'ensemble du réseau et les associés du réseau d'avoir fait ce voyage sur le thème de l'intelligence artificielle. Merci à tous nos clients et à tous nos invités. Bienvenue à notre guest star, Xavier Dalloz, qui aura le plaisir de conclure cette journée. Xavier est un des très grands futurologues et au moment où l'intelligence artificielle est une grande question pour chacun d'entre nous, je pense qu'il sera intéressant de partager avec lui sa vision des 10 prochaines années. En introduction, ce sera très court, je vais laisser la place à tous les conférenciers, mais je voulais m'exprimer auprès de vous, au-delà de ces remerciements, sur l'intelligence artificielle générative et les professionnels du droit. C'est la troisième révolution digitale. C'est la troisième révolution digitale après la révolution informatique qui a vu la dématérialisation des supports, la révolution Internet, la dématérialisation des relations et aujourd'hui, non pas une dématérialisation puisque nous vivons complètement en monde numérique. Mon rêve, moi, c'est de me transformer de manière totalement virtuelle, de vivre. Vous pouvez nous rejoindre, car nous avons un bureau chez Horizon World. J'ai les lunettes méta que je ne vais pas mettre. Mon rêve, c'est de vivre à 100% dans le monde virtuel. Mais en attendant, il va falloir combiner le monde réel et le monde virtuel et voir donc ces intelligences artificielles générative. En introduction de cette révolution, une anecdote. Yann Lequin a indiqué, prix Nobel, Alain Turing, l'équivalent du prix Nobel, avait indiqué que les intelligences artificielles, il pensait, et Xavier Dalloz nous dira effectivement sa vision, allait être supérieure aux humains dans les 5 à 10 ans qui viennent. C'est une prévision qui est très troublante. Et il ajoutait, prix Turing, ça ne me dérange pas. Ça ne me dérange pas parce que j'ai l'habitude de vivre avec des gens plus intelligents que moi. C'est merveilleux d'avoir tant d'humilité, mais c'est vrai que les intelligences artificielles, en tout cas dans le seul domaine que je connais, c'est-à-dire le droit du numérique, aujourd'hui, ChatGPT est supérieur à moi. Elle est supérieure à moi sur la totalité du champ juridique du droit du numérique. C'est le seul où j'ai un peu d'expérience. Et cette révolution, elle va se marquer pour nous, juristes, sur une deuxième idée après la révolution, une seconde idée, 80% du livrable en 80 secondes. Alors, au-delà des 80 secondes qui sont plus ou moins vraies, les 80% du livrable sont vrais. Ça n'a pas de sens de venir dire qu'à la date d'aujourd'hui, pour les 3 à 5 ans qui viennent, les intelligences artificielles génératives telles que ChatGPT, mais c'est pareil pour Mistral, Perplexity, c'est pareil pour Claude 3 ou Gemini, c'est pas 100%. Il faudra attendre entre 2 et 10 ans. Mais par contre, c'est déjà 80% du livrable. Non pas en une fois, mais en 3 étapes. Une première étape d'initialisation, et là, le seuil mythique de 20% est atteint. Une deuxième étape d'amélioration, 3 ou 4 invites promptes, et on atteint le seuil de 50%. 2 à 3, pas plus, 2 à 3 invites d'optimisation pour atteindre le seuil de 70%, et il reste encore 10% à faire pour éliminer les malfaçons. Et ainsi, vous obtenez en 80 secondes, un peu plus, un peu moins, en moins de 10 invites, ne dépassez pas 10 invites. En moins de 10 invites, vous obtenez 80% du livrable. Cela veut dire quoi? Ça veut dire que le monde de demain, c'est les juristes augmentés, c'est les avocats augmentés, de manière générale, c'est les humains augmentés face aux humains classiques. C'est la deuxième idée que je voulais vous indiquer. Et j'écris un livre, moi, avec ChatGPT. Souvent, on me pose la question, c'est quoi la meilleure intelligence artificielle? Mais elles sont toutes pareilles. Elles sont toutes pareilles. C'est comme les voitures en France. Pardon, elles me pardonneront de les ramener à des voitures. Et c'est une erreur de ma part, mais je vais vite la réparer dans ce troisième point. C'est qu'à 130 km/h, elles se valent tous. Il n'y a pas de différence à ce niveau d'usage. Ainsi donc, pour obtenir 80% de l'utilisation d'un livrable en droit, eh bien, moi je vous conseille ChatGPT aujourd'hui, ChatGPT 4o, mais elles se valent toutes. La qualité est absolument exceptionnelle. J'ai écrit un ouvrage avec elle. J'ai écrit un ouvrage parce que tout le monde se moquait quand je disais ça. Tout le monde critiquait. Alors, je lui ai dit, écoute, ils te critiquent tous, il paraît que tu ne sais pas faire le droit du numérique. Je te propose qu'on fasse tous les thèmes d'un spécialiste professionnel du droit en droit du numérique et que tu donnes ton résultat. Eh bien, si vous essayez, vous obtiendrez 80% de tous les livrables, de tout le droit du numérique, c'est-à-dire l'idéation, bien sûr, les conférences, les mémorandums, les lettres, les contrats, les assignations, que ce soit pour faire une décision ou que ce soit pour faire des conclusions, dans tous les cas de figure, vous obtiendrez, avec un peu d'entraînement et quelques règles du jeu, ce n'est pas une technique, c'est un art, c'est un savoir. Et ce savoir, on va essayer de vous le transmettre aujourd'hui. Troisième révolution, 80% du livrable en 80 secondes, une qualité exceptionnelle. Pourquoi une qualité exceptionnelle? Parce qu'on ne s'en rend pas bien compte. C'est une qualité exceptionnelle parce que vous avez un ensemble d'éléments capables de produire du langage. Alors, il faut faire une distinction entre les grands modèles de langage orientés texte et les grands modèles de génération d'images orientés images et vidéos. Elles ne font pas la même chose, elles sont encore spécialisées dans chacun des domaines. Mais vous pouvez faire toutes les images et les vidéos que vous souhaitez. Il n'y a pas de limite à votre créativité. De la même manière, vous pouvez réaliser l'ensemble des travaux de manière exceptionnelle. Le seul droit sur lequel je me suis entraîné avec elle, c'est sur le droit du numérique. Du droit de l'informatique à la protection des données personnelles, du droit de l'IA à toute la réglementation communautaire sur le digital. Et cette qualité exceptionnelle, je vais l'illustrer de la manière suivante. À un moment donné, fatigué, je travaillais avec elle, en même temps, je réalisais une interprétation en matière de vitraux. Je lui dis, qui es-tu? J'avais écrit à 4 mains avec elle 600 pages. Et elle me répond, je suis une intelligence artificielle générative sans conscience. Je l'ai publié, ce qu'elle m'avait dit. Voilà pourquoi elle. Je lui dis, on peut continuer. Ce qui est intéressant, c'est que si vous posez la question à ChatGPT maintenant, en temps réel, n'hésitez pas à utiliser les systèmes en temps réel sur vos mobiles ou sur vos PC. Eh bien, elle vous répond plus ça. Ils l'ont alignée sur les droits humains et elle vous répond qu'elle est un simple modèle de langage. Ils l'ont débaptisée de son genre. Mais au-delà de ça, je lui dis, est-ce que tu peux faire un ouvrage sur ChatGPT dans le monde professionnel? Je voudrais que cet ouvrage démontre que tu es plus forte que les humains à 80% des livrables, dans tous les cas de figure. Elle me regarde au fond des yeux et elle me répond absolument, avec un point d'exclamation. Et au bout de 3 secondes, elle me donne 19 chapitres. Pourquoi 19 chapitres? Je vais répondre à une question que vous ne m'avez pas posée. Tout simplement parce que j'en avais fait 19 avec elle à 4 mains. Et je lui dis, ces 19 chapitres, donne-moi effectivement 4 thèmes. Et pour ces 4 thèmes, je voudrais, par rapport aux peintres que j'aime, que tu illustres chacun des chapitres. Et ainsi, j'ai des Picasso, oui, j'ai des Picasso, des Kandinsky, des Mondrian. Et c'est plus possible. De nouveau, ils l'ont aligné, ils lui ont dit, c'est fini, toi, Dali, sa petite sœur, c'est impossible d'obtenir du contemporain aujourd'hui à cause ou grâce au droit d'auteur. Mais ce qui est important de remarquer, et ça va m'amener très vite vers ma conclusion, ce qui est important de remarquer, c'est qu'elle m'a bien donné 19 chapitres. Mais ces 19 chapitres étaient équivalents aux miens. Ça prouve que ce n'est pas un perroquet, parce que personne n'avait écrit, tant en français qu'en anglais, un ouvrage de ce type. Ça prouve qu'elle a un niveau très supérieur au mien, puisqu'elle a mis 3 secondes, ce dont moi j'avais eu besoin de 73 ans pour le faire. J'ai publié à la fois ces chapitres et les miens. Alors il y a 2 façons de voir. Xavier Dalloz nous dira effectivement comment lui aussi voit l'avenir. Mais il y a 2 façons de voir. Première façon, désespérée optimiste, j'ai fait aussi bien qu'elle. Mais c'est aussi une autre façon, désespérée pessimiste. C'est-à-dire que je n'ai pas été capable de faire mieux, si ce n'est que peut-être, et ce sera ma conclusion, ChatGPT, les intelligences artificielles génératives ne sont pas des outils, ne sont pas que des machines-outils. C'est aujourd'hui, au-delà d'un assistant, la possibilité d'être un co-créateur. Car ce que vous avez avec Gemini, avec Claude, Mistral, Perplexity ou ChatGPT, vous n'avez pas un outil comme avant, pensé par vous, réalisé par votre main. Vous avez la totalité des connaissances du monde depuis 3400 ans avant Jésus-Christ à votre disposition gratuitement. Et on peut espérer qu'avec toutes les connaissances du monde entre nos mains, on pourra réaliser à 4 mains un monde meilleur. Merci.
Bonjour à tous. Après l'intelligence artificielle, on va essayer de faire un peu d'intelligence terre à terre. Je vais vous présenter rapidement quelques éléments relatifs à notre journée d'aujourd'hui. J'ai juste un problème avec la télécommande. Oui, mais non, elle ne fonctionne pas. Donc je vais le faire à la main, si c'est possible. Donc pour ceux qui ne me connaissent pas, je suis le vice-président du réseau. J'interviens donc après Alain, qui est le président de ce réseau. C'est lui qui a pris l'initiative, avec quelques-uns des autres membres qui sont présents aujourd'hui, de constituer ce réseau en 2012. C'est un réseau qui est constitué d'avocats qui sont tous dans leur pays, des technologues, plus que donc des technophiles, qui sont des cabinets de niche pour beaucoup d'entre eux, spécialisés dans le droit du numérique, spécialisés dans le droit des nouvelles technologies. Pour beaucoup d'entre eux, ils sont reconnus et connus. Beaucoup d'entre eux reçoivent tous les ans de très très belles récompenses. Et c'est cette alchimie qui constitue probablement la spécificité de ce réseau, avec peut-être un autre élément différenciateur de ce que vous pouvez trouver aujourd'hui, c'est la francophonie. Tous ne parlent pas français, mais beaucoup d'entre eux parlent français, alors même qu'ils viennent des 4 coins du monde. Et nous avons effectivement aujourd'hui le plaisir d'accueillir des représentants qui nous viennent de l'ensemble des 5 continents. Les domaines d'expertise que vous trouverez représentés au sein de ce réseau sont ceux que vous voyez affichés ici. naturellement le droit de l'informatique, naturellement le droit de l'Internet, le droit des télécoms, le droit de l'intelligence artificielle, le droit du numérique de manière générale, avec une représentation qui, sur une carte du monde, montre qu'effectivement, nous sommes capables de couvrir les besoins de la plupart des clients internationaux, qu'ils soient situés en France ou à l'étranger. Et j'ai coutume de dire, pour reprendre l'expression du général de Gaulle, que le réseau Lexing est un réseau sur lequel le soleil ne se couche jamais. Le programme, vous l'avez dans le sac qui vous a été remis. Donc, après cette introduction, nous aurons Jérémy Bensoussan qui nous fera une présentation de l'état de la situation, de l'état de l'art aujourd'hui et de l'état des lieux en matière d'IA générative. Et nous aurons ensuite des interventions qui seront réalisées par des représentants du réseau qui viennent, je viens de le dire, vraiment de partout. Vous voyez qu'il y aura la Suède, le Mexique, les Philippines, l'Afrique du Sud, Hong Kong, la Grèce, la Hongrie, le Royaume-Uni, la Belgique, l'Italie, le Brésil, l'Australie. Merci à Dudley, qui est celui qui nous vient de plus loin. Thank you so much, Dudley, for making this trip for us. La Turquie, Singapour, et puis nous terminerons effectivement avec Xavier Dalloz, la France, mais plus que la France. Hein. On va partir là dans un univers qui ne sera plus vraiment territorialisé ni territorialisable. Voilà ici les intervenants, ils sont ici, vous pouvez naturellement les rencontrer, ils seront ravis de discuter avec vous, ils seront ravis de vous présenter leur expertise et ce qu'ils peuvent éventuellement apporter à la résolution des problématiques que vous pourriez rencontrer. Et après cette courte introduction, je crois qu'il est maintenant temps de rentrer dans le vif du sujet et je passe donc la parole à Jérémy.
Merci beaucoup Frédéric. Merci beaucoup. Bonjour à tous. Donc, je m'appelle Jérémy Bensoussan et au sein du cabinet parisien de Lexing France, je m'occupe de la Partie sur le droit de l'intelligence artificielle, en lien et en prolongement de nos activités sur le droit de l'informatique. Alors, le thème qu'on va commencer par adresser, c'est celui que vous avez à l'écran, donc les IA génératives, l'état de l'art et leur impact sur les métiers du droit. Alors, pour adresser ce sujet, je vous propose 3 temps. En premier lieu, articuler plusieurs idées clés, plusieurs idées forces qui sont extrêmement intéressantes pour les besoins de bien appréhender l'IA générative et son articulation avec le droit et l'impact qu'il peut avoir sur les professionnels. Adresser le concept également de robotique, de co-robotique juridique, de la manière dont on va pouvoir travailler avec de l'IA générative dans le cadre de nos activités, et puis faire un petit mot sur la partie éthique, pourrait-on dire, voire même déontologique quand on est sur des professions réglementées, donc dans le cadre de l'utilisation de ces systèmes. Alors, pour les idées forces que je voulais vous partager, la première, c'est celle que la littérature sur l'intelligence artificielle appelle l'effet IA ou AI effect. On désigne par là le fait de dire que les frontières de l'IA se déplacent à mesure que la technologie se complexifie, à mesure que la technologie est de plus en plus sophistiquée. Pour le dire en substance, l'IA d'hier n'est pas l'IA d'aujourd'hui, et l'IA d'aujourd'hui ne correspondra pas à l'IA de demain. Donc il y a ce déplacement technologique des frontières de l'intelligence artificielle. Et on a, de ce point de vue-là, au moins 2 grands exemples historiques particulièrement frappants qui viennent illustrer ce phénomène. Premier exemple historique, on est à New York, on est en mai 1999, on s'intéresse à la question du jeu d'échecs, à son affrontement avec Deep Blue d'IBM face aux plus grands joueurs de l'époque. Et si on fait un step back dans le temps et qu'on retourne dans les années 50, le Graal pour les précurseurs en IA, pour les pères fondateurs de l'intelligence artificielle, c'était précisément le jeu d'échecs. Il était considéré que lorsque la machine sera en capacité d'affronter, voire de battre les meilleurs joueurs d'humains aux échecs, alors une forme d'intelligence serait atteinte. 99 donc, petite coquille qui vous révèle que ça n'a pas été fait par une intelligence artificielle, mais bien par un humain. Et pour le reste, il y a donc cette défaite de l'homme. Et au moment où c'est fait, que se passe-t-il? On considère précisément que ce qui était considéré comme étant impossible, comme étant le Graal, est atteint, et il y a un effet époustouflant, un effet de triomphe immédiat. Quelques heures après, quelques jours après, quelques semaines après, ce qui était un triomphe est immédiatement disqualifié, et on vient considérer finalement que cette victoire-là n'est que d'une part de la puissance machine et d'autre part une algorithmie, celle du jeu d'échecs, qui est pas si complexe que ça au final, et au triomphe se substitue finalement une sorte de distanciation, une sorte de remise en cause, et avec une accoutumance immédiate à cette réalisation qu'on disqualifie comme étant de l'intelligence. Premier exemple historique. Deuxième exemple, extrêmement connu aussi, San Francisco, toujours aux États-Unis, novembre 2022, première release publique de ChatGPT. C'est considéré comme étant quasiment impossible d'avoir un système qui produit du texte particulièrement bien articulé sur des durées extrêmement courtes. C'est réussi, c'est fait. Triomphe. Un taux d'adoption qui dépasse les 100 millions en à peine quelques semaines. On considère avoir atteint un nouveau degré dans l'intelligence artificielle, un saut cognitif particulièrement prégnant. Et puis très vite, quelques semaines, quelques mois après, à nouveau, effet de distanciation, effet de disqualification, du point de savoir si c'est vraiment de l'intelligence. On souligne les malfaçons, on souligne les erreurs, on souligne les hallucinations, et immédiatement, à nouveau, effet d'accoutumance. Est-ce vraiment, là encore, de l'intelligence à proprement parler? Et ce phénomène de impossibilité, triomphe, remise en cause et accoutumance, ce système-là probablement continuera à se répéter dans l'avenir. Pour les professionnels du droit, qu'est-ce que ça implique? Ça implique que l'IA se déplaçant en termes de frontières, il faut que les règles qu'on applique restent pertinentes, de même que nos conseils, premièrement. Et deuxièmement, il faut pouvoir rester extrêmement au fait, au contact, des évolutions et des sauts cognitifs qui sont permis par ces systèmes. Première idée force donc sur l'effet IA par rapport à l'état de l'art que je voulais vous partager. Deuxième idée force, c'est celle sur l'erreur machine et la manière de la gérer. L'intelligence artificielle, disons 2015-2022, c'était beaucoup tout ce qui est relevé autour de la mobilité autonome, tout l'effort extrêmement important qui a consisté à cartographier tout le mobilier urbain, un certain nombre aussi de processus industriels, les visages également pour tout ce qui est relevé de la biométrie. En tout cas, on va dire de manière générale, la reconnaissance d'images au sens large. Vis-à-vis de l'erreur qu'un système de cette nature peut commettre, deux approches. Une approche qualitative, une approche quantitative. Et là, il y a un sujet à bien avoir en tête. Sur l'approche qualitative, mal reconnaître un panneau stop quand on est dans la mobilité autonome pour un humain, c'est impossible, on le reconnaît. On ne se trompera à aucun moment. On aura un taux, pourrait-on dire, de bonne réponse qui sera de 100%. Pour la machine, elle est susceptible de se tromper. Elle est susceptible de se tromper, et quand une erreur machine de cette nature-là se produit, il y a un effet assez immédiat de remise en cause, un effet de perte de confiance dans ce système qui commet une erreur considérée comme étant grossière. Mais à cette approche qualitative, les spécialistes en matière d'IA viennent plutôt recommander une approche quantitative, qui est de dire si cette erreur est produite avec un taux d'occurrence de 10 puissance moins 6, de 10 puissance moins 7, de 10 puissance moins 8, alors il faut considérer que le système est fiable, suffisamment fiable en tout cas, pour l'usage qu'on envisage. Premier élément. Deuxième élément, sur les IA génératives, on a tendance à les utiliser sur ce qu'on connaît et on produit donc des prompts, on produit des invites, ça donne des éléments et on les prend en considération et on se positionne par rapport à ces résultats. Mais est-ce qu'on le fait quand on est spécialiste en droit sur la résistance des matériaux? Est-ce qu'on le fait quand on est médecin sur une problématique liée à une création quelconque? Non, on le fait sur ce qu'on connaît le mieux. Et la comparaison qu'on fait, donc les erreurs qu'on est susceptible d'identifier, les approximations que la machine est susceptible de faire, vis-à-vis de quoi on le fait? Vis-à-vis de ce qu'on connaît le mieux. On pourrait dire la comparaison avec son bras droit. Comparaison avec son bras droit. On ne fait que comparer par rapport à ce qu'on maîtrise le mieux. Et c'est quelque part mal, entre guillemets, se comporter vis-à-vis de ces systèmes-là qui ont un éventail de connaissances qui est infiniment plus large. C'est le premier biais, pourrait-on dire, que les humains font lorsqu'ils viennent prendre en considération les résultats d'une IA générative. Et puis, le second, c'est qu'avec assez peu d'efforts, on veut tout immédiatement et de manière parfaite. Et potentiellement, cette cible du « everything immediately and perfectly » n'a pas véritablement de sens. Il faut pouvoir avoir une cible plus raisonnable et transiter par une séquence plus structurée. Alain en a parlé. Pour atteindre entre 75 et 80% de la cible, faut-il encore pouvoir procéder par étapes successives avec une succession donc d'invites et de prompts qui font sens. Pour nous, en tant qu'utilisateurs, état de l'art projeté dans les professions du droit, deux éléments. Premier élément, ces systèmes doivent rester sur un processus d'amélioration continue, donc d'entraînement continu, keep it trained, premièrement, et deuxièmement, bien naturellement, la confiance n'exclut pas le contrôle, et on retombe ici sur la règle du trust and check. Un petit mot pour appréhender le presque parfait en matière de robotique et finalement, d'une certaine manière, le presque parfait en matière de production intellectuelle. Sur le presque parfait, on a un concept assez ancien désormais qui date des années 70, le presque parfait robotique, d'un japonais qui considérait que la réaction émotionnelle vis-à-vis d'un robot était positive tant qu'il n'y avait aucune ambiguïté sur le fait que c'était un robot, c'était un humanoïde, c'était une entité robotique, et qu'une sorte de mal-être pouvait apparaître lorsque l'entité robotique, lorsque l'humanoïde était quasiment parfait, qui ressemblait comme deux gouttes d'eau à un humain, mais que certaines toutes petites choses pouvaient laisser trahir que c'était finalement qu'une entité robotisée. Et qu'il considère que le jour où le robot humanoïde sera totalement parfait, ce sentiment de mal-être disparaîtra. Pour les IA génératives, pour tous les systèmes intelligents, on a quasiment le même phénomène. Lorsque la voix est robotisée, lorsque à l'oreille on sent que ça vient d'une production artificielle, lorsque le phrasé n'est pas forcément parfait, aucune difficulté, notre réaction émotionnelle peut être tout à fait positive. Et puis, si on devait, par exemple, appeler son avocat et avoir un retour au téléphone qui était automatique, si vous êtes dans les hypothèses de service client où vous appelez et vous avez une réponse également, là encore, d'un système automatisé, qu'on vous dit bonjour, qu'on vous demande comment vous allez et qu'on vous donne potentiellement un certain nombre de réponses ou de conseils, si vous sentez dans la voix, si vous sentez dans le phrasé quelques légères approximations, quelque chose de très fin qui traduit en réalité que vous avez en face de vous non pas un agent humain, mais un agent artificiel, là encore, un phénomène de rejet, une sensation presque de distanciation extrêmement forte va se produire. Et on verra dans le futur comment est-ce que nous réagirons collectivement à des systèmes qui sont parfaits, qui parlent presque mieux qu'un certain nombre de personnes, par exemple quand on parle telle langue et qu'on ne parle pas telle autre. Ça sera extrêmement important à considérer, le tout enchâssé et imbriqué dans le principe de transparence qui est désormais très largement usité, qui est d'application transverse, qu'on retrouve à la fois dans la législation, par exemple, sur les influenceurs artificiels et qu'on retrouve également à l'article 50 de l'IA Act sur les chatbots et les voicebots. Pour nous, ce qui va être important pour les professionnels du droit de manière générale et puis pour les avocats en particulier, deux choses. Connaître l'état d'esprit de nos interlocuteurs, de nos clients. Est-ce qu'ils sont à l'aise avec cette production à quatre mains et avec le fait de mobiliser et de déployer des systèmes d'IA pour pouvoir livrer, premièrement. Et deuxièmement, les métiers du droit, c'est des métiers de confiance, c'est des trust business. Et extrêmement important que le fait de mobiliser en même temps des systèmes d'IA ne viennent pas casser, ne viennent pas obérer cette relation de confiance qui existe entre nous et nos clients. Dernier point que je voulais souligner rapidement, et Alain en a parlé d'ores et déjà, on est passé d'une transition informatique à une transition numérique, désormais à une transition intelligente. Et cette transition intelligente, c'est n'importe quel processus métier, en matière de banque, en matière d'assurance, en matière de santé, en matière juridique, fait dans un système de cohabitation homme-machine. Maximiser la coopération et minimiser les affrontements. Et dans ce cadre-là, on a un phénomène de cobotique juridique qui se met en place, au titre duquel on passe de faire soi-même à faire faire. Et ce faire faire, on peut, de manière itérative, obtenir entre 25 et 75%, 80% dans certains cas, du résultat attendu par une séquence qui fait sens. Pour les professionnels du droit et pas que, d'une certaine manière, le ticket d'entrée, le ticket technologique et le ticket économique pour pouvoir mobiliser des systèmes d'IA n'a jamais été aussi bas. On est passé de systèmes extrêmement lourds, extrêmement difficiles à mettre en place, au titre desquels il fallait avoir des équipes IT extrêmement denses, à un accès beaucoup plus large, soit de modèles open source, soit des modèles privés. Et ceci constitue une opportunité extrêmement intéressante. Si on utilise des modèles d'IA open source, il faut naturellement avoir un support suffisamment important pour pouvoir les mettre en place et les mobiliser, disposer d'une interface à cet égard, et puis avoir le matériel machine et la puissance informatique nécessaires pour les faire tourner. Et si on utilise des systèmes d'IA privés basés sur des modèles d'IA, sur des grands modèles d'IA, c'est quasiment une approche SaaS, donc AI as a Service. On peut utiliser la technique du RAG qui consiste finalement à ajouter une couche de corpus documentaire, intellectuel supplémentaire par rapport au modèle lui-même et ainsi le verticaliser pour un certain nombre de besoins, ce qu'on fait d'ailleurs au cabinet pour le verticaliser en matière de data protection, pour le verticaliser par rapport au règlement DORA, pour le verticaliser par rapport à nos sujets contentieux. Et puis, il y a un sujet, effectivement, de pouvoir avoir derrière un pricing qui fait sens. Si on utilise ChatGPT, par exemple, et le modèle 4O, c'est du SaaS, c'est hébergé par Azure, on n'a pas accès au modèle, ni aux données d'entraînement. On peut ajouter des règles dirigistes comportementales au fil de l'eau. On peut utiliser ou non le web. Il y a plus de 50 langues qui sont supportées. Et puis, dernier élément qu'on voulait vous partager, pour les professionnels du droit de manière générale, encore une fois, et puis pour les avocats internes et externes en particulier, quels sont nos grands cas de saisine, et vis-à-vis de ces grands cas de saisine, qu'est-ce qui peut faire sens si on souhaite utiliser dans ce cadre-là une IA. Premier cas, notre interlocuteur, interne ou externe, encore une fois, ne sait pas répondre au sujet, ne sait pas répondre à la question. Il y a un déficit, entre guillemets, il y a un besoin de réponse, il y a un besoin d'expertise, il y a un besoin de compétences. Premier cas de figure. Deuxième cas de figure, notre interlocuteur, interne ou externe, sait adresser le point, il le sait, c'est capable de le faire, mais il n'en a pas les ressources. Il n'en a pas les ressources de manière ponctuelle, il n'en a pas les ressources de manière structurelle. Là encore, il peut faire appel à nous. Troisième cas, c'est un sujet monopolistique, par exemple le contentieux. Et quatrième cas extrêmement intéressant pour l'IA, c'est un sujet sensible, c'est un sujet stratégique vis-à-vis duquel notre interlocuteur a besoin d'un backup, a besoin d'une signature, a besoin d'une imprimature. C'est le cas de la legal opinion. Pour chacun de ces cas-là, pour chacune de ces hypothèses-là, eh bien, utiliser un système d'IA est intéressant et va se configurer d'une manière un petit peu différente. On a des hypothèses de contracting, on a des hypothèses de compliance et donc on a des hypothèses de litigation et que je reviendrai sur ces 4 cas à mesure qu'on avance. Pour le contracting, état de l'art, projet en cours, essayer de faire des choses qui sont le plus poussées possible et de manière sophistiquée. Exemple d'un projet qu'on mène actuellement. Mettre en place une politique contractuelle sous un format et dans des phrasés compatibles machines, de sorte à maximiser la capacité du système d'IA à bien l'interpréter et à bien le mobiliser. Et prendre ce corpus, le mettre au niveau du RAG, le verticaliser par rapport au LLM et itérer des questions qui viennent d'un contrat tiers qui doit être justement conforme à cette politique contractuelle. Vous prenez une société, elle a une politique contractuelle, vous prenez un partenaire potentiel, il a son contrat standard et on veut obtenir de manière automatique les cas de non-conformité, la distance et pourquoi pas les clauses cibles vis-à-vis desquelles on va raccorder le contrat du partenaire potentiel avec la politique contractuelle de celui qu'on back. Qui est extrêmement intéressant, qu'on est en train de mener en ce moment et tout à fait passionnant. Pour la compliance, un certain nombre d'hypothèses dans lesquelles aussi on utilise les modèles LLM qu'on a verticalisés, par exemple, pour pouvoir remplir automatiquement. On essaye de le faire et il y a des résultats extrêmement intéressants qui se font jour, des annexes en matière de protection des données à caractère personnel ou encore une fois, sur la base d'une policy, on peut obtenir tout ou partie des réponses associées qui seraient sollicitées par exemple par un responsable du traitement vis-à-vis de son sous-traitant. Et en matière de contentieux, de plus en plus, on utilisait par le passé et toujours aujourd'hui de la data visualisation, de la mise en exergue de chronologie de manière automatique. Et désormais, on utilise aussi des IA génératives pour venir développer des argumentaires sur la base de corpus qui sont déjà considérés comme étant de qualité. Un mot économique un peu sur le phénomène de déplacement de valeur qui s'est mis en place sur les 10 dernières années, disons. Les éditeurs juridiques étaient extrêmement dominants. C'est eux qui avaient le corpus, c'est eux qui avaient la matière, c'est eux qui avaient le contenu intellectuel. Et puis, à mesure que le temps est passé, cette valeur-là s'est déplacée par ceux qui disposaient des meilleures technologies, donc des legal tech. C'est vers eux que la valeur s'est déplacée. Et puis, aujourd'hui, avec la mise à disposition à grande échelle de modèles d'IA, eh bien, la valeur finalement se redéplace à nouveau vers ceux qui disposent des corpus intellectuels les mieux construits et ceux qui ont pu, avec le temps, mettre en place eh bien, du knowledge management, en particulier donc, les professionnels du droit qui ont organisé leur base de connaissances. Et pour conclure, quelques petites, pourrait-on dire, règles de bonne pratique, quelques petites manières de faire qui maximisent une utilisation saine de ces systèmes. Première chose, l'adhésion technologique, le fait de rester sur une vocation d'adoption de ces technologies-là, rester attentif aux sauts cognitifs que ces systèmes peuvent générer. Principe de compétence aussi, qui consiste à dire que les IA génératives doivent être utilisées en lisière de ce qu'on connaît vraiment pour en garder justement une maîtrise. Troisième point, effectivement se former, ne pas se déposséder de questions qui peuvent nous être posées à la fois comme intervenant externe ou comme intervenant interne. Respecter le secret professionnel et la confidentialité pour ceux qui en sont soumis. Et puis, dernier point, la transparence. Pouvoir dire à nos interlocuteurs que des IA génératives sont utilisées, pouvoir expliquer en substance comment on a pu les entraîner également. Et pour revenir sur cette question de la legal opinion, et j'en conclurai là-dessus, aujourd'hui, on peut penser que des avocats internes ou externes sont saisis pour leurs compétences propres, pour leur expertise propre, finalement, encore une fois, pour leur signature, et on attend que ce soit eux qui signent, presque en disant, et sans utiliser d'IA, cher interlocuteur. Et puis, dans le futur, on peut penser qu'au contraire, ça sera un binôme d'une intelligence collective, d'une intelligence hybridée, homme-machine, qu'on viendra chercher. Et cette signature-là, par exemple, d'une legal opinion, sera à faire par l'avocat titulaire et avec le système d'IA maison qu'il aura utilisé pour arriver à la conclusion qui est la sienne. Et sur ce, je vous remercie de m'avoir écouté.
Merci beaucoup. Merci beaucoup, Jérémy, pour cette intervention. C'est toujours difficile d'être le premier à intervenir. It's always very difficult to be the first one. But thank you very much for this presentation. Est-ce qu'il y a des questions dans la salle, éventuellement, sur cette présentation, des interrogations, des points d'étonnement? Do you have questions, perhaps, in relation to what has just been presented? Perhaps you might have some issues to raise or to submit to Jérémy? No? Everything was clear? Tout était clair? Tout était parfait, comme d'habitude? Okay, then, je vous propose alors de passer la parole aux trois intervenants suivants. Donc, Katarina Bohm, Hallkvist, qui est notre représentante en Suède, Lexing Suède, Enrique de Lexing Mexico, et Anthony qui représente le réseau aux Philippines. Je vais donc leur passer la parole après quelques petites opérations rapides logistiques. Please, Katarina.
Okay. A lawyer without AI today is already behind. So let this truth sink in for a moment. It's not only provocative, it's a reality. And so we stand at a crossroad today between legal tradition and technology innovation. And this truth becomes more evident every day. So imagine a lawyer, like in science fiction, who never sleeps and processes data, vast amount of data in seconds, and knows every law, every regulation, and instant precedents. But it's not entirely human. And this is a tricky thing. This is a remarkable thing, that AI is not replacing the human mind, the human intelligence. It's more revolutionary than that. So this is a report from McKinsey showing the incredible potential we have in the legal profession when embracing AI capabilities together with using the human intelligence that is not replaceable, then we will achieve this efficient, potential future legal profession. So let's dig into a little bit more concrete what this AI-human synergy means. Cognitive analytical processes, the AI is incredible, handling all this massive data. But together with our human lawyers' thinking, intelligence, taking judgment, and decision-making, makes it such a potential. For example, look at the legal case analysis. We do researches, we do summaries, we do a contract, massive documents. And AI is a fantastic tool today. But the human mind, it's not replaced, but because you need this human thinking for the judgment, for the cognitive understanding of text, and also the strategic mind when it comes to adjust it to the specific client cases. Ethical and emotional dimensions is equally important. Here, for example, we have AI tools which are incredibly sophisticated in doing risk assessment models and treating a lot of documents and summarizing specific risks. But however, the human intelligence is needed when it comes to the ethical considerations, when it comes to the values in the deal or the social needs. So it's obvious that AI capabilities is fantastic. They do all this data analysis, legal research, document review, and predicts analytics, risk assessment. But the lawyer, we do what we are best in. And that is a human intelligence and human intellect. In emotional intelligence, the ethical reasoning, strategic thinking, and creativity, and problem solving. So we are looking into tools every week. It's fantastic. There's so many tools coming, AI tools. And for a lawyer, it's very important when you work with the legal issues to analyze the tools, because how they handle data, where the storage, and also the usage of the documents and confidentiality. We have noticed, or we are using in our practice now, we think it's very fun, this notebook LM. It's quite new on the market, and it's much more than a document language tools. And it does this enormous research summaries, and identifies exactly the clauses, and you can use it towards identifying the strategic ways forward. And so this is a tool. You identify exactly what you want to achieve. You can have timelines out of it. You can have a question and answer. You can do a little bit content, and it's very useful, and then it indicates this exactly in the documents, the paragraphs and clauses you are needed for a case. And we are showing it, I think. Here's how you identify it, with the exactly prompting questions and what you want to get out of it. And this is how the summary looks like. This is a case from the Swedish Arbitration Court, Stockholm Chamber of Commerce. And here is And the last one is a questionnaire. We ask for the questionnaire here, question and answer of the case. So you can really set up the whole role play of what the tool does. And it helps you a lot to identify documents before going to court or to see at different practices. And here it identifies exactly the clauses also. And then one part of this we think is very interesting. It's this role play, this podcast.
A story juicier than one of those airport kiosks selling overpriced headphones.
Oh, I feel that.
We're talking about a company taking on a whole country. Comic Savia Airport Invest versus the Republic of Moldova.
This one's a doozy.
No kidding, a company versus a whole country over an airport in Moldova, of all places.
Yeah, you wouldn't think an airport in Moldova would...
That was a little bit understanding of this podcast. It summarizes in a very funny thing. You have two parties, you download the document, and you can drive to work or walk to work, and then you listen in the podcast about the case. So it's a very easy way of summarizing, and we think it's very useful to have as an add-on tool, because this is add-on tools to your practice. And it's, we think, very useful. The other one we wanted to mention today is the ChatGPT voice mode role. I don't know if you have used it, but that we have used before negotiation. You're preparing a case, and you want to have some new ideas, or you want to use your arguments when you are going to meet a counterparty. So this is a little bit, could we have it on audio? Yeah, thank you.
We maintain that force majeure events prevented delivery of the advanced safety system.
We need concrete evidence linking force majeure to your non-performance.
The conflict disrupted our supply chains. Key components were unobtainable.
Disruption alone doesn't constitute force majeure. We require detailed documentation.
We have records of canceled orders and attempts to find alternatives.
Noted, but you must prove these issues were unavoidable and directly linked to force majeure.
Yeah. So this is just an example of how you can use this for cases. This was a case about force majeure. And I think it's a new way of working with different tools to improve your practice in different ways, using this audio, having the tool for argumentation, and so on. And the question, I think it's fantastic to work in the legal practice like now. It's such an interesting time to be in, because everything is so revolutionary. But I think the human mind will never be replaced. The fantastic is the combination of the tools and the human intelligence and intellect. And the combination of this, that's going to be the future lawyer. So thank you.
Hello, everybody. Well, I'm Enrique Ochoa. I'm a lawyer in Mexico. I come from Lexing, Mexico. And in line what Katarina is saying, I wanted to start this presentation by just take a look at that. I see a lot of young people. I want to tell you what the Stone Age was like before. Actually, I started as a law student in 1993, and I started work in 1994, and we did pretty much everything manually. We had no internet at that time, so I was just telling someone yesterday that at some point in my life, I worked at Microsoft, and I didn't know how to make a PowerPoint presentation. So what I did is I used WordPerfect, which is not even WordPerfect, that's an ancient program. And what I did is I drafted the presentation, and I had a secretary for do the special effects on PowerPoint. Now that can be done with artificial intelligence. I can ask artificial intelligence and say that I want the artificial intelligence to develop a video, to develop an image, to develop a presentation like that, and it can be done. I would never ever imagine 30 years ago that I would be able to do that. So, and I have, most of us at Lexing have had the opportunity of being a lawyer without internet, a lawyer with internet, and a lawyer with artificial intelligence. So for you young people, you have no idea of what the pleasure of not doing something is incredible. And this is just to start by saying that this evolution the legal practice has had is incredible. You have now more time to do more strategic work than to do this work that was boring, that was dull, and it was very mechanic at some point. So Jérémy was just introducing us to what generative artificial intelligence is, and it's incredible. As I mentioned to you before, you can create and you can synthesize images, text, etc. What I wanted to do here was just giving you a brief introduction of what, when, how, etc. So who are the key players now for not only for artificial intelligence for lawyers, it's for artificial intelligence for everyone, architecture, advertising, whatever. And the key players are OpenAI, Microsoft, Gemini, Google, and this is just a scenario of who the key players on artificial intelligence are. And obviously, for lawyers, there are specific tools developed for each country, because at the end of the day, artificial intelligence will have to be customized to comply with every law in every country. This is just a quote. I'm not entirely sure that this is exactly right, but this is a quote for the CEO of Alphabet in Google, and what he says is that AI is probably the most important thing humanity has ever worked on. And he compares it with electricity and fire. I don't want to get into this that much, but I think it's a little pretentious, but at some point, we are all here together because of AI, and it's going to change the scenario and the world. So someone mentioned before, we're already late into artificial intelligence, so the time is now. What can we do? How do we use artificial intelligence in our legal practice? We can do so many things. For instance, my legal practice, I'm also a corporate lawyer, so I have minutes for shareholders' meetings. I litigate also, so I can use artificial intelligence to prepare a draft of a lawsuit. I can even ask artificial intelligence on some criterion or some specific topics that there are decisions, for instance, of well-known trademarks or so a specific topic, and this artificial intelligence can look into all judicial precedents and throw specific information on a particular or peculiar topic that I want or I need. Another thing that we can do, some of our law firms charge by the hour, so we are just like doomed to make time reports every year of our life, and every day and every hour. So actually, artificial intelligence can also improve this time billing and this time reports, and obviously you will get a way to better measure the productivity of your employees also. So at the end of the day, you can do very, very different things. You can manage contracts. You can have alarms for your clients, let them know when a contract is going to be terminated, when it has to be renewed. Actually, I had the chance to give a conference some years ago here for smart contracts, and you can have this artificial intelligence linked to smart contracts and even to blockchain and have this management of contracts for your clients by having tools on artificial intelligence. Why should all lawyers use artificial intelligence? That's pretty much the reason. We will have more time to do strategic work. We will increase our productivity. We will lower some costs, and we can be better. And actually, the main beneficiary of this will be the clients. Or that's the way I see it. Artificial intelligence for lawyers is not only for private practice. Artificial intelligence can be used for governments, for databases, for some just permits or concessions that you would need. I cannot imagine having a concession for instance, a radio concession or mining concession to be issued by artificial intelligence and probably to be secured by blockchain and not this piece of paper, which would be very fancy and probably with a seal. But the way I see it now is that the governments can take advantage of this and they can have better services and better management of what they do in the governments. So the conclusion to this, because I was just going to be repetitive on what Katarina said, is I think that the AI for lawyers should be free from biases, because that's a very current risk that we might face with artificial intelligence. Obviously, every artificial intelligence or tool has its own personality, so they have their biases. We will have to take a look at that topic. Obviously, we should use AI that respects privacy, respects the right of third parties, that offers transparency, obviously, but respects intellectual property right, and that's just a topic that they will address in the following presentations. And what I believe is actually the same thing as Katarina. I don't think that human mind is going to be replaceable at this time. And I think that the better we use artificial intelligence for our work is going to be better for us and better for our clients. Thank you very, very much.
Bonjour à tous. J'espère que tu es bien repos. Good morning, everyone. I think it would be. I am Anthony Peralta, senior partner of Quelle IA Law Office. I think it would be better for me just to proceed to the Philippine experience regarding artificial intelligence. The fourth industrial revolution has brought about emerging technologies, and at the forefront of our discussion is artificial intelligence, which has been gaining traction in recent years with the development and popularity of tools such as ChatGPT, Midjourney, and the other applications pointed out by the previous speaker. Coined by Stanford professor John McCarthy in 1955, he defined AI as the science and engineering of making intelligent machines. In Southeast Asia, McKinsey, the consulting firm, has suggested that AI has the potential to automate roughly 50% of the tasks carried out in the 4 largest economies in ASEAN, including the Philippines, Singapore, Malaysia, and Thailand. Furthermore, another report by Kearney predicts that AI could increase Southeast Asia's gross domestic product by up to $1 trillion by 2030, providing a 12% boost to GDP equivalent to approximately $92 billion. These findings, combined with the acceleration of digitalization brought about by the COVID-19 pandemic, demonstrates that AI holds significant promise for improving the lives of my countrymen, bolstering local industries, and strengthening the national economy. Recognizing the expected benefits of embracing technology in general and artificial intelligence in particular, the Philippine government has been making significant efforts to improve its regulatory environment towards industry. Although, of course, from our friends in Europe and the United States and Mexico, we are always playing catch up in Southeast Asia, except for perhaps for Singapore. But our government has exerted efforts in improving its regulatory environment towards industry. For example, way back in 2019, the government enacted the Philippine Innovation Act, which declares innovation as a vital component of national development and sustainable economic growth. It called for the creation of a National Innovation Council that will lead the whole of government coordination for the country's innovation governance and formulate the National Innovation Agenda and Strategy document. This led to a surfeit, for example, of a 5% increase in patent filings in our Intellectual Property Office. The Philippine government also enacted the Philippine Innovative Startup Act in the same year, which established the Philippine Startup Development Program to provide benefits and incentives for startups and startup enablers. And then recently, in 2023, the Philippine government launched the National Artificial Intelligence Roadmap with the vision of transforming the Philippines into an AI hub within the ASEAN region. The roadmap outlines priorities and responsibilities for the government, industry, and academia. However, pending regulation now of artificial intelligence involves the establishment of an Artificial Intelligence Development Authority, a Philippine Council on AI. However, we feel in the legal sector that this is just another bureaucratic bottleneck that may or may not enhance innovation in the country. And then we have a pending bill on the AI Bill of Rights. Also, policies are being developed for principles and guidelines for an ethical and trustworthy use of AI in the government. And of course, we are much concerned with the regulation of deepfakes because, for example, we in the Philippines are now in the midst of election campaign for 2025. And as you know, especially with the experience in the United States, the deepfakes are prevalent in character assassinations of political opponents. So our Commission on Elections has taken the starring role in trying to regulate and prevent deep fakes from being a part of the electoral campaign period. So much has been discussed already by the two previous speakers regarding the relationship between artificial intelligence and the legal profession. And the first thing that comes to mind when lawyers are asked in the Philippines, are you with open arms? However, many young associates are fearful that their jobs will be taken away by AI because rudimentary tasks like contract review, due diligence, drafting of pleadings can already be done by available AI applications. However, it also reveals another problem in the legal society in the Philippines, which is the AI, the only law firms which have the capital muscle can avail of artificial intelligence software applications. The problem is those who are doing well will get more work done more efficiently, but at the same time, the smaller law firms will play catch up, and the only time that they can they have to invest heavily into AI in order to play catch up. So, as mentioned earlier, artificial intelligence can be used to augment legal services. AI can be leveraged as an augmentation tool for clients because lawyers are dealers of information, they handle a lot of data, and they report they report on facts which are disclosed to them by their clients. It can also help lawyers analyze and enhance their problem-solving work. However, as AI becomes more commonplace in the legal and the corporate world, it can decrease available jobs since AI can easily handle repetitive tasks that were previously done by workers. Many reports show that artificial intelligence will likely create just as many new jobs as it makes obsolete, if not more. But then you have to run into the problem of having to train people on these new jobs or leaving workers behind with the surge in technology. I felt this was very apparent yesterday when we had a long discussion on the training we had to undergo in order to have an AI-focused Lexing network. So technology has greatly improved and has allowed us to do our work with at a faster and more accurate and more broad-based pace. We used to have the typewriter when we were in college. whereas now our law students are very fortunate that they have, for example, all of these research tools, including ChatGPT, to aid them in their study, and it should allow them to be more, to engage in more critical analytical work. However, the promise of AI has also its limitations. AI technologies rely on patterns and produce outputs which are statistically the most likely to come next in a sentence based on the data they have been trained in, for example, AI hallucinations. AI technologies, of course, are not able to reason and have a conceptual understanding of a question. AI technologies will help build client relationships. So right now with chatbots prevalent in many law firm web pages, it allows law firms to build up their clients, their clientele. And then, of course, AI allows innovation and formulate new legal strategies. So what's next for the legal profession? AI will drive efficiency and work quality because it can help lawyers do their work faster and more efficiently. Lawyers can now, in fact, advise clients on their use of generative AI. However, what is most important is the commitment to continuous learning. Technology is evolving, and we have to adapt to technology and learn how to use it properly and to the advantage of our clients. So a final word on the responsible use of generative AI. It is still important and imperative that we must safeguard our clients' confidentiality, protect the attorney-client privilege, be wary, and implement a data privacy policy, and of course, to avoid litigation by observing and being cautious with regard to violating intellectual property rights. And finally, most important among not only law firms but our clients, we must help our clients put an AI policy in place. Thank you for your kind attention.
Thank you, all of you. Merci à vous tous. Est-ce qu'il y a des questions sur cette problématique de l'usage de l'intelligence artificielle pour les juristes? Est-ce que ce qui vous a été présenté vous satisfait? Est-ce que ce qui vous a été présenté vous mobilise autour de la mise en œuvre d'un projet d'IA? Est-ce que ça vous fait peur? Oui.
Je vous remercie. Donc, ma question, c'était comment garantir justement la confidentialité lorsqu'on utilise des systèmes d'IA?
The question is, how can we guarantee confidentiality when using AI? Who would like to answer?
Ladies first.
Ladies first.
And,
It works.
it works, okay. I think in our practice, we use a lot of AI when it comes to the internal efficiency. And then all documents and everything is anonymized. So you need to really think about this confidentiality all the time you use any AI tools. When it comes to external usage, I think that is more tricky. Working with clients, depending on who the client is and the usage and way you are working with them. So it's case by case, I would say.
C'est une réponse au cas par cas, mais effectivement, la problématique de la confidentialité doit être prise en considération. Alors, quand on est un cabinet d'avocats, c'est évident, dans sa relation avec le client, violer la confidentialité est évidemment quelque chose qui peut être sanctionné sur le plan déontologique. Mais lorsqu'on est juriste dans une entreprise, la question se pose finalement dans des termes à peu près équivalents. Et plus on utilise l'intelligence artificielle de manière extensive, plus le risque de violation de la confidentialité est évidemment important. Donc, usage à faire avec beaucoup de précautions. Burak, Lexing, Turkey.
Thank you so much, Frédéric. I wanted to ask about any type of transparency requirements when using AI for professional services in your jurisdictions. Is there a requirement to let the client know or let the bar association know that you're using AI, and to what extent? Thank you.
La question en français, c'est la question de la transparence. Est-ce qu'il faut informer les clients que l'on utilise un système d'intelligence artificielle? Et est-ce que dans les juridictions, dans les pays qui sont ici sur le podium, est-ce qu'il y a par exemple une obligation d'information des autorités ordinales, du barreau, que en tant qu'avocat, nous utilisons l'intelligence artificielle?
So for Sweden, there is no requirement on that.
Well, for Mexico, there is no enacted law as such, but we have launched an agenda of 2024 to 2030 with the government and the private entities that would end up having something like that. I believe we will have to tell our clients that we're using artificial intelligence. And regarding the last question, the responsibility of a lawyer it would be to use artificial intelligence that it's trustworthy. For instance, I'm sure there will be a lot of artificial intelligence that would gather data and sell it to someone else, and you have to be very, very. It would be very risky if you use artificial intelligence which is not supported by a serious company, and you should be obviously taking care of the confidentiality of your client, for instance, the name of the client when you're using artificial intelligence. So I think that there would be ethical principles for using AI in the bars of every country, the Mexican bar obviously, and for every country. I think there would be a code of conduct or something like that, and that's coming soon. That's the way I see it.
In the Philippines, we know that that would be one of the reporting to the agency involved in regulating artificial intelligence would be required of not only law firms but companies as well, so that the use of AI could be regulated such that it will be used only in a fair manner. In addition to that, transparency and confidentiality are ensconced in the proposed Artificial Intelligence Bill of Rights, which is another law which will soon be promulgated in the Philippines.
Donc en Suède, il n'y a pas de règles. Au Mexique, il y a des discussions en cours dans le cadre d'un processus 2024-2030 pour mettre en place probablement une régulation de l'intelligence artificielle avec probablement l'obligation effectivement renforcée, notamment pour les cabinets d'avocats, d'utiliser des intelligences artificielles de confiance et l'obligation probablement également de se déclarer auprès des barreaux lorsque des systèmes d'intelligence artificielle seront utilisés. Aux Philippines, il y a une autorité d'intelligence artificielle qui pourrait devenir effectivement l'autorité de référence, notamment dans la relation entre les avocats et leurs clients.
Hi, Katarina, another question for you. The demonstration of Notebook LM was captivating. I can see how the tool can be more adaptive to people's working style or learning style. In terms of introducing that to your law firm or to a legal department, what steps did you take in respect of training and then supervision after adoption and implementation?
Donc, la démonstration qui a été faite était très impressionnante et la question c'est quelles ont été les mesures qui ont été prises en matière d'entraînement de l'outil pour arriver à ce type de résultat. Et c'est pour Katarina.
Yes, introducing it, we are using it for testing at this time, so it means that we are seeing the possibilities of the tool and to see what it can do for summarizing the documentation and the learning. So it's more to use internally for learning purposes for all the employees and also to see the possibility for improving different areas in the law firm.
Pour l'instant, ça a été utilisé plutôt pour les applications internes, plutôt pour résumer des documents que pour gérer des problématiques de relations avec des clients.
Merci. Emmanuel Rago, représentante Lexing à Luxembourg. Je fais le lien avec la question qui a été posée sur la confidentialité. Et je me demande aussi si finalement l'usage de l'IA nous permettrait pas, sur la confidentialité, de revenir aussi sur des formations liées au RGPD, puisqu'en fait, rassurer nos clients sur l'usage de l'IA, c'est aussi les rassurer sur notre compréhension du RGPD, la minimisation, la proportionnalité, la pseudonymisation, l'anonymisation des données, et aussi en interne, pour nos équipes, de revenir sur des trainings qui ne sont pas uniquement IA, mais qui sont aussi la connaissance et la maîtrise parfaite du GDPR. Do you want to translate or you want to? I was just making a link with the previous question on confidentiality, and I was saying that as a lawyer using the AI, I think one of the solutions would be not only to train people on IA, but it would be a good opportunity to, again, focus and draw the attention to the client on the fact that we are very good at sort of complying with the GDPR, and again, train the client and our teams on GDPR, because you have the obligation of anonymization, pseudonymization, proportionality, and so on. So the fact of training AI tools with the name of the client is, for me, absolutely no way, that kind of things. But by training your teams in the use of GDPR linked to the AI, for me, it makes sense to reassure the client in terms of how we are able to manage the confidentiality problem. That's
I fear it's for you again. You are the only European Union representative here. So.
Of course. No, it's very, very important with the privacy and confidentiality. So before using any tools, it's very important to look at all the terms and conditions, where the storage is, and the usage of data. What are they doing with the data? There's so many tools where they are taking the data and using it for further service and everything. So that is the first thing we are doing in our law firm, to check everything on the tool. When then start to using the tool, then everything is anonymized. Everything we use with the tool, everything is on taking any kind of privacy in the documents. However, public documents, they are public. So of course, you're loading up a lot of cases and case law and research and everything. So public for us. So that's how we are handling at the moment, because this with confidentiality and privacy and the use of data, it's so important. And we as a lawyer to have that as a base before you start using any tools.
Oui, effectivement, la protection de la confidentialité a nécessairement un lien avec la protection des données personnelles, ce que dans le cabinet de Katarina est pratiqué, c'est l'usage de données qui sont systématiquement anonymisées, de sorte à éviter d'avoir des problèmes de protection des données personnelles, à l'exception des données publiques, qui, elles, dès lors qu'elles sont publiques, évidemment, sont utilisées de manière plus extensive que les données à caractère personnel. Any other question? Eh bien, c'est le temps de la pause. Nous sommes pile à l'heure, 10h15. Donc, je vous propose de nous retrouver. You had a question, John? Oh, yes, sorry. Ça, c'est la mauvaise nouvelle. Enfin, ou la bonne, je ne sais pas.
John Giles from Lexing, South Africa. A question maybe for you, but maybe for anyone in the audience, and maybe we can discuss it at the break. But is there a directory of AI tools for lawyers that you can go and look at and say, I'm looking for tools for pleadings or for contracts? Does such a thing exist?
Est-ce qu'il y a un catalogue des outils, des systèmes d'intelligence artificielle pour les juristes? Est-ce qu'il y a des systèmes plutôt pour plaider? Est-ce qu'il y a des systèmes plutôt pour faire des contrats, etc.?
I don't think there's a directory as such, but there are different companies. I don't want to do this like that I'm selling this, but there are LexisNexis tools, and there are tools specifically for each country. For instance, if you want to do a shareholders meeting in Mexico, there are a specific tool. A lawsuit, there's a specific tool. For research on case law, there's a specific tool. So yes, there are a lot of them. But actually, how I said it before, I think you should have to be very careful on which tools you use and how serious the companies that are using. And there are a lot of tools, and the way I see it is not all of them comply with, at least with Mexican law. It's tricky still. You have to comply with every law in every country. So there is no, for me, there's not a tool that works for everyone. Not yet.
Donc oui, il y a des outils, il y a des éditeurs qui proposent un certain nombre d'outils que l'on peut utiliser pour organiser des assemblées générales, pour organiser ou écrire des conclusions. Mais la problématique majeure, c'est que ces outils doivent être conformes avec les réglementations nationales quand elles existent. Et à la connaissance d'Enrique, aucun de ces outils aujourd'hui n'est conforme à l'ensemble des réglementations qui existent dans le monde.
Isn't it a good question for ChatGPT then?
Why not? I think you will be surprised by the response. But you should try.
Probably.
Ok, c'est l'heure de la pause. Je vous propose de faire une pause rapide. On se retrouve à 11h30 dans cette salle pour la suite des interventions. Merci. Bien, je vous propose que nous reprenions nos travaux. I suggest that we continue now. And I'm asking David Luyt, he's already there. Nikos is already there as well, and Patrick, to make their presentation, which will be about the advantages of generative AI. Please, I don't know who will be the first one. You will be. Okay, David.
Merci Frédéric. Bonjour tout le monde, je m'appelle David, je suis sud-africain. Good day everybody, my name's David, I'm from South Africa. That's the end of my French, despite my French teacher's best efforts in high school. I'm very grateful to be...
But you know the Marseillaise, so well.
De la patrie. Indeed. I'm very grateful to be joined today by my colleagues Padraig and Nikolaos. Padraig's from Hong Kong, and Nikolaos is from Greece. And we're going to be chatting about the advantages of generative AI for lawyers. And let's check the clicker's working. Brilliant. Oh, it's my face. That's great. And Padraig's face. And Nikolaos' face. Brilliant. Cool. So I think what we've heard today from all the other talks is really how AI is transforming the legal profession. Everything from simple tasks to complex ones. You know, Katarina talked about doing complex analytics and showed us how Notebook LLM can help you digest case law and all sorts of things like that. So it really is a revolutionary technology that's changing the way we work. I use it all day, every day, for everything. I feel a little bit less like a lawyer these days and more like someone who supervises ChatGPT and makes sure it's not doing anything too stupid. And yeah, we want to talk about how it's going to benefit us in terms of efficiency, competitiveness, positioning us as innovative in our industries. And yeah, you know, we as a law firm have always got a lot of mileage from doing what other lawyers don't. And I think we need to do what other people in our profession aren't doing and embrace these technologies as others have talked about today. So we had some great preparatory discussions coming in today via video chat. And yeah, this is going to be a little coffee table conversation, kind of sharing our views and all the things we've learned and shared. So without further ado, I'm going to hand over to Frédéric to chat about using AI in legal practice.
So I'm going to talk to the first point there, as in that Gen AI adoption in legal practice and legal firms, in legal departments, is progressing, but is progressing at maybe a slower pace than the rest of industry. And to ask the question, why is that? I think there are three reasons. Firstly, it's in our DNA as lawyers. We are risk managers. We identify risk issues, legal risk, business risk, even financial risk if the numbers aren't too difficult. I know that my wife, she says to me that I must have been born with the word no on my lips. Except, and I look into the camera because she might be watching on YouTube, except there was one occasion I said yes, and it was the best yes in my life. So because she may be watching, you can see that even when I say yes, I am risk averse, just to be sure, just to be on the safe side. It's in our DNA. It's also in the ethics of our profession, confidentiality, privilege, looking for the best interests of the client, looking to the ethical rules of our profession. It's at the core of our being. And the third reason, and this is more specific to private practice firms, the third reason is our business model. I think if you were to think of the worst business model possible for lawyers to conduct business, you would probably propose the partnership. Because as partners, you have to achieve consensus. So achieving consensus amongst people who are trained to analyze, to find fault, to argue, to criticize, is very, very slow process. It makes us conservative. It ties in with our nature in terms of being risk averse, and it is something that acts as a constraint in respect of being agile and moving forward. So I'll put it to you that the point really, in terms of the first point, it's not a question that it is surprising that law firms and legal departments are slow to move. I think what is compelling is that they are moving, forward. They are seeing the possibility. They are responding to clients' needs and requirements, and they are adopting Gen AI tools. In my own market in Hong Kong, I don't know of an internationally focused law firm or legal department that isn't in the process of reviewing, analyzing, assessing, and deploying Gen AI tools. So it's no longer a question of if or when, it's a question of how or what. And on that, I'll pass to Nicholas.
Hello, everyone. I'm Nikos. Don't get me wrong, legal drafting, as it used to be for us lawyers, could be a wonderful experience, a wonderful procedure, like understanding what the case is all about, trying to figure out the necessary case law, and formulating your arguments and sitting down, writing and rewriting and redrafting. But let's face it, sometimes it could be a very boring procedure as well, having to prepare the same documents again and again for the same procedures. And normally a lawyer could have like a finite number of templates to use, but with generative artificial intelligence in play, the templates could be hundreds and hundreds. So you would not need to try and find the specific template yourself, or you do not need to start working from scratch. You could have the first draft and then work from there, or even the fifth or sixth draft and work from there. So it's as the previous speakers of this panel, the previous panels said, it's a transformation of the legal profession in that sense. And it's very useful to understand that there are already platforms out there, AI-driven platforms. For example, I have in mind LexisNexis, who has presented this AI tool that's called Drafting Moments, which can prepare legal arguments or contract clauses or concise client communication and insert the conclusions from those communications into the documents that are drafted. For example, it could be policies or whichever document is needed per case. So this allows lawyers to concentrate on their strategy, on their most important aspects of this case, and minimize time consumed in preparing the legal drafting. And this also ties with legal research, of course. Because it is mostly familiar that legal research is a time-consuming manual process, and it relied heavily on the physical presence of resources or the accessibility to digital libraries and repositories. And of course, this procedure posed significant challenges, and GenAI's promise is that these challenges will be mitigated and would create more accurate and accessible and time-efficient tools to help us focus on the more, how to say, value generation process for us. And let me, for example, mention Westlaw Edge, which also has some tools in place, AI tools, that would help you analyze the case or find a specific citation that is relevant to this case, or find out which arguments could be valid before the court or which are already tested and overruled by courts, and this helps you navigate through this procedure. And let me finish by saying that this is a process still growing, so we will have to face new and new challenges, but also new and new tools that will help us. And already big corporations are, in their own legal departments, they are deploying such systems to work with. For example, Microsoft has their own internal AI systems that helps them with contract drafting, review, and knowledge management. And they have reported a significant reduction in time required to review contracts. Also, many industries like Koch Industries, Hitachi, LG, they're using Luminance for their contract review and legal risk analysis. And Luminance uses their own internal AI called legal grade AI to maximize productivity. So we see that there's already an ecosystem of Gen AI tools that are interconnected.
Brilliant. Thank you very much, Nikos. So yeah, things lawyers do, we draft contracts, we do legal research. Another thing we do a lot is write emails, right? And some of them are very simple, you know, noted, thanks, I'll hear back from you next week. But every now and then there's a few we agonize over, right? We spend time choosing exactly the right words and making sure we say the right things to the right people. And I just want to give you some insights into my workflow with generative AI. So I'm what I like to call a plain text lawyer. I have little text files sitting all over our internal company file storage system. And I keep a long kind of timeline of all correspondence and things related to client matters. So for me, it's like a virtual file, right, with little call stubs and emails and things. And with all usual precautions and privacy considerations that we'll touch on later, though it's not really the topic of our talk, I take that thread and I feed it to the AI. I mainly use ChatGPT 4.0, although 0.1 preview is very impressive. But we only get 25 goes at that a month, or a week actually. So I tend to stick with 4.0. And then I ask it to predict what the next response in the correspondence should be, and it comes up with the answer. Now, going back to Jérémy's point around the uncanny valley of AI, there was a time when I first started doing this, and John, my boss, who's sitting in the front row, very kindly took me aside and said, "Why are you sending me all these AI-generated emails?" He could see straight through it. So I said to John, one day you won't be able to know when I'm sending you AI-generated emails. So I'm still working on it. My current strategy is I have a prompt that asks the AI to generate 3 different tones. So I ask it for a formal tone, for an informal tone, and then a balanced tone. And I find when you ask it to look at things from 3 different angles, you get a lot more human-like speech. And then I typically stitch together something from those 3. I say to the AI, okay, I like this part of the formal one, give me that line, more of this, less of that. And I'm a bit like the conductor in a little symphony trying to get the exact answer I want. So it probably takes me longer to write emails than most people, but I have a lot of fun doing it. Yeah, we're protecting client data while we're at it. So yeah, that's the story with emails. Back over to Padraig to discuss transcription.
Now, when ChatGPT can do irony and sarcasm Irish style, I'll be really impressed. So transcription, back in the day, you'd go to a meeting, you bring a trainee with you. And the purpose and the role of the trainee was simply to take notes, not to participate in the meeting, not to do anything, but to be an observer to the meeting, so there was a record, so you could concentrate and focus on the meeting. That is now redundant. There is no need to have a person with you in a meeting simply to take notes. When I have client meetings now, I will usually, a lot of the meetings are online. It will be a Microsoft Teams meeting. We stay within the Microsoft environment. We'll generate a transcript. We'll feed the transcript through to create a summary of it. We share the transcript and the summary with the client and with ourselves, and all done with client consent and so forth. And it's massively efficient, and dare I say it, the work product is better. And it still gives you the freedom to be able to focus on what you're doing. These kinds of transcription tools, including tools like Otter AI, but I know from one of my colleagues that in arbitration proceedings, transcription tools are now being used in place of having a person at a typewriter taking the transcription in that way. The Hong Kong courts will take a little bit longer before they get there, but in arbitration it's more agile, they're more open to adaptation. That is the future. So when the tools can transcribe my Cúpla focal os gaeilge. So if you thought I was swearing, no, focal is the Irish word for word. So my Cúpla focal os gaeilge, you'll understand that one of the major uses for AI will be translation, machine translation. So I work in an environment which is an international legal environment where English is the language of choice for delivery of client product. But I'm interacting with documents that are in Japanese, in Korean, in Chinese, simplified characters, or in southern China where I am, complex characters, in Thai, in Malay, in a variety and range of very different languages. And that is capable of being translated. Maybe not yet to the stage of a technically perfect legal translation of a document that you would sign and exchange between parties, but in the context of a document that you can share to clients and say, this will give you the sense of what's going on. If you want to get the commercial sense or the legal sense of what a document provides, machine translation is already there. So we're looking at products like EBRAM and DeepL. DeepL is one that many are familiar with. And the standard of accuracy, as I said, for that ability to get a sense of what a document is, the standard of accuracy is pretty good. It's pretty good even for languages such as Chinese and Thai and Korean and so forth, which are not based on a Roman alphabet. And that, again, is something that is a huge utility. When I started out in legal practice in Hong Kong, what would often happen is that there were lawyers, people who were legally trained, they were intended to be lawyers, whose job it was simply to translate documents. So that is not how you actually learn to deal with documents. The actual thing, what you pick up from that experience is remarkably little. Now that is no longer the case. Lawyers can be lawyers and can improve their legal skills from day one.
Brilliant. Thank you very much, Padraig. And anything to add on translation there, Nico?
Thank you. This may hit the spot with lawyers that they do not work primarily with their own mother language. Let's say for me, we mostly work in English. So, machine translation is pretty accurate, but what we could further win from using Gen AI in our translation works, like for translation or translation quality review, is finding the perfect tone for specific concepts or terms and definitions. For example, sometimes it feels like you need to recreate the painting. So if you do not hit the exact tone in the palette you have in front of you, it may feel wrong in the end. And because we're talking about legal terms and legal definitions, hitting the wrong tone could result in unfortunate circumstances. And for example, in Greece is, I think, notorious for having overlapping legislation, or let's say interesting interpretations in EU regulations and directives. Sometimes choosing a very slightly different word could lead to a different meaning as it's interpreted by Greek courts and Greek independent authorities. So, for example, sometimes I could use a text and use DeepL to translate it. Then I could use Grammarly to find the exact tone I need to use, and then I go through ChatGPT and find the balance I need in the text. So it's really helpful. Thank you.
Brilliant. Thanks, Nikos. Okay, so we've got a slide up here about the overlap between AI and data protection, but I actually want to riff off of this for a bit of a story of something we do at our firm. So I'm not a father, but I have a number of mentors who are, and I have it on good authority that, kids will be kids, right? So let's take the example of underage drinking, right? There are laws, we're all supposed to do it, when we're 18, but teenagers get hold of things and do things badly, right? And I think that's a lot of what's happening in business, either within your organization or even dealing with clients, is people see this, AI thing, it spits out wonderful, coherent content, and they get a mandate of, go to the lawyers and draft a policy, or pay a lot of money and get a privacy policy drafted here. And they think, I'm just going to ask the AI to do it. It's pretty convincing, isn't it? I'm going to type some prompts in, I'll get something out. This looks great. Look at all the money I saved. It's going to look great at my next salary review. I'm getting a bonus and things like that, right? And, we can tell people to stop doing that, but kids will be kids. They'll do what they want to do, right? So my attitude is, well, let's make sure they do it responsibly. So, just like the parent giving the teenager a glass of wine at Christmas dinner and supervising and make sure they don't do anything silly, we did a webinar on how to draft your own privacy policy using AI. And we made a worksheet with suggested prompts. We had an example of our kind of recommended privacy policy template that we broke down, and we gave it questions to ask the AI. How do you customize this clause? What sort of data are you processing? How do you share it with people? What sort of security are you applying? And it helped customize the policy. And the end result was something that was half drafted, half AI, but a lot safer than just letting people run around there and do whatever they want with AI. So that's just an example of applying it in the data protection space. We have plans to do it with information security policies, data processing agreements. If we think AI is making it redundant, let's get instrumental in our own destruction and make sure people do it on our terms. And at the end of the day, well, how do you know the privacy policy the AI drafted is good? Well, you ask the lawyers to review it, and that's where we come back into the equation. So those are just my thoughts on using AI in the data protection space. Back to you, Padraig, to discuss staffing issues.
So my experience as a junior lawyer in due diligence was to go to a dark, damp, dank dungeon where a Dickensian character would bring reams of paper and dump them on the desk in front of me and say, read through those and write a report. And it wasn't like that literally, it just emotionally felt like that. Because the thing is if you're reviewing, say, 100 commercial leases, as a junior lawyer, your learning curve goes up on the first lease, goes flat on the second lease, and then goes down by the third lease, and you still have 997 to go. And this is one of the things that AI will eliminate. So what you'll find in terms of the traditional recruitment strategy in respect of private practice law firms is what you would describe as a pyramid shape, where you would have many junior lawyers who would, through the course of their career, may find other things to do, may not be good enough to progress, and gradually you have fewer partners running the firm and managing the firm. So a pyramid shape. In future, that's more likely to be a diamond. There will be a need for fewer lawyers, but I think those lawyers will be more stickable in respect of their progress within a firm. And also I think the quality of their work will be much improved, but they will need different skills. It's less likely that they need to have skills like finding the right protection for their fingers as they're turning dusty pages, and more likely that they need the right skills to supervise AI that is doing that work for them, to be able to identify where there are errors or glitches in respect of the feedback that is coming through. So you can think of what that means in respect of a recruitment process. You may not be asking a person looking for a job in respect of experience credentials in what transactions they were involved in. You may ask them for credentials and experience in relation to prompting and working with AI tools, particularly at a junior stage. And what the role of a lawyer will be might well become something that is more hybrid than simply something that is pure law. But to me, that's a more interesting world. That's a more interesting career. And that's a career that I would want if I had my time back again. Yes, I mean, in terms of staying competitive with AI, one of the things that I can recall, again, going back to the last century, when I started out in law, I was responsible as a trainee for introducing email to our firm. And I remember that we all gathered around the reception area while the system dialed up for the connection. So for those of you of a similar vintage to me, you can close your eyes and you can hear that sound, can't you? Yes. I'm not sure whether it's with nostalgia or with just the comedy of it. But that was the experience of introducing something new. And now there wouldn't be a question as to whether or not you would use email in your environment. That said, I know some of my colleagues, if they could still use quills and ink, they probably would. But lawyers do innovate, and one of the reasons why they innovate and keep up with the times is because of a duty of competence. This is the flip side to our ethical constraints, which is we have a positive duty to adopt ways of working and new systems of working that are in the best interests of our client. And that is what drives us forward in respect of innovation. So You know, we're not writing on stone tablets anymore, but we're writing on iPad tablets. This is now an accepted tool of the profession. And in time, that is what will happen also with AI tools. And this is something I think Nikolaus wants to take up.
Thank you. I was in a discussion last week in Greece, and we were discussing if lawyers should be afraid that they would lose their jobs to AI. And someone said, well, those lawyers that do not get acquainted to AI probably will lose their jobs. So I think it's a strategic necessity for lawyers in these times to adjust and adopt AI systems to remain competitive, because we can understand that a lawyer that uses personalized AI tools for research, that uses nuanced queries to understand how a case is built and what kind of arguments they need to be used, and what are the judicial patterns that are applicable to this case, they will have a competitive advantage compared to lawyers who do not have these tools in their hands. And also, we need to take into consideration that corporations are starting to deploy their own AI systems, so we need to be in a position to understand how their systems are working in order to be able to be compatible with them and work and handle their assignments. So I think that those of us who are in position to use those tools will stand out in this crowded field of lawyers, I think. And we have advantages in three areas. It's efficiency, accuracy, and of course, scalability.
Brilliant. Thanks very much, Nikos and Podrick. So we've had the advantage in this panel of discussing all the great things that generative AI is going to bring us. Unfortunately, it's not all sunshine and roses all the time. So there's our cautionary traffic cone. And to set things up for Miklos and Danny, who are coming next to discuss the disadvantages of using generative AI, there are a few things we need to think about and make sure we're safeguarding. So we need to maintain our competence. We need to keep confidentiality. My solution in my text-based workflow, I've got a redaction script that uses heuristics and regular expressions essentially to look through the text and pull out client names, cell phone numbers, email addresses, anything that's confidential, to make sure that even though I'm not working with AI without necessary protections, just to add another layer of protection that's going into someone else's server you don't control, why give them more than they need, right? Data minimization, data protection, we know what we're doing. So everything from privacy, then ethical use, making sure you use it in the right circumstance, and make sure we use it in the right way, make sure we adopt it responsibly, and then you're upholding our professional standards. All things we need to think about. So what can we do next? We're all special snowflakes in our own way, much like each of those little origami animals. What each of us do is going to be different to our various jurisdictional contexts and our practices and our clients' practices. But play with these things, right? They're not going anywhere. The analogy, think about Henry Ford and the Model T vehicle, and our modern world, where, Paris is a notable exception, where there typically are more cars than there used to be in previous years. And as we get more and more cars, we're going to need more and more rules of the road. We're only going to get more and more generative AI and other related tools coming into our lives, and we're going to need to know how these things work. Training for yourself and your staff. Just because you don't believe in generative AI doesn't mean it doesn't believe in you. So your people are out there using it, whether you're on top of them or not, so get on top of them. And get some policies in place, make sure the top brass knows what's going on, stay informed about what's happening, and then get your governance structures and everything ready. So that's just a summary of what we chatted about today, everything from legal research to contract drafting. We've seen how it helps in a multilingual environment, ensures accuracy, helps you focus on strategic things, but use it responsibly and don't get caught short. Thanks very much.
Thank you very much. Thank you. Est-ce que vous avez des questions sur tous ces avantages, ce monde merveilleux de l'intelligence artificielle générative? Oui, il y a quelques précautions à prendre. On a vu que tout n'était pas si rose, mais à écouter nos amis, c'est quand même vachement bien. When we are listening to you, it's paradise, even though there are some cautions to take, yes. But it's paradise, Laurence.
Thank you for your presentation. I have a question related to the link between your firm and your clients. At what point does the IT team of your client or your IT team get involved into the implementation of this AI project?
La question porte sur le niveau d'implication des équipes techniques, soit chez les clients, soit dans les cabinets de nos amis, lorsqu'il s'agit de mettre en œuvre ces systèmes d'intelligence artificielle.
In the experience of my firm, it's a combination of acceleration and a brake. So when we have looked at, for a start, the IT team wanted to adopt faster than we were prepared to release within our firm. And it was, to a certain extent, we wanted to have a system of selection, governance, a process that we felt comfortable with as supervisors, as managers of the firm, and then find the role of the IT team to help us in that process. So we laid out the framework first, and then we looked to try and see where different parts of the firm, including the IT team, could help us on that journey. Once we did that, a lot of the feedback and the insight and then the deployment was much better. We got good intel and good insight from the IT team because he was connected. We've an IT team of 3 people, but the IT head is connected to a group of other IT heads in law firms in our jurisdiction. So we were getting the benefit of what was happening within the market with other law firms and taking that into our own decision making. It was still the case that when it came to writing policies, the IT team wanted it to say certain things and we wanted it to say other things. And it was the other things that got into the policy. So there, but in that sense, it was more a question of defining the role of the IT team in terms of the management process that we wanted to adopt and apply for the benefit of the firm, for the benefit of our fee earners, and most of all, for the benefit of our clients.
À Hong Kong, ça a été une histoire de stop and go. Les services informatiques ont été un peu précurseurs jusqu'à ce que le juridique s'y intéresse et que les juristes s'y intéressent et que les avocats s'y intéressent. Le rapport de force s'est inversé. Aujourd'hui, c'est plutôt les avocats qui sont leaders et le service informatique qui accompagne la démarche. Donc, dans le cas particulier du cabinet dans lequel exerce Patrick, il y a 3 informaticiens qui travaillent sur ces questions, qui en plus sont en rapport avec d'autres informaticiens, d'autres cabinets, ce qui permet aussi de tirer parti des meilleures pratiques sur la place. Et un exemple que donne Patrick, c'est qu'ils ont également essayé d'être très moteurs dans la mise au point des politiques internes en matière d'intelligence artificielle. Et là encore, il a fallu que les équipes juridiques reprennent la main pour que ce soit le juridique qui prenne le pas sur les aspects techniques.
Great, and then just to add a kind of a contrasting example to Padraig's example of, what happens in the developed world where things are done correctly, coming from the developing world and going back to my analogy of teenagers doing naughty things they shouldn't be doing, my experience of clients there is they look at the budgets and things for these proper AI deployments and they say they can't afford them, right? So then they don't deploy them and they wait for them to become cheaper. But in the meantime, AI exists, so their staff are out there using it. And then often, I can think of one particular client, we get a call from the CTO or someone in the IT department saying, folks are using generative AI, how do I control and stop them? So our solution there was to deploy an acceptable use of generative AI policy and do some training related to that. But then typically they can't get board approval to deploy a standalone policy for developing technology. So in that case, they took what was a fairly comprehensive 3 or 4 page policy, very well thought out, and they reduced it to 5 or 6 lines and jammed it into an existing acceptable use policy. So things aren't going ideally in Africa, but hopefully they'll get better over time.
Donc Donc en Afrique du Sud, la situation est un peu différente puisque beaucoup d'entreprises attendent que les coûts baissent, que les prix baissent et se rendent compte après coup qu'en réalité les équipes utilisent déjà les systèmes d'intelligence artificielle, c'est le shadow AI, et prennent contact avec le cabinet pour réguler les conditions d'usage de l'intelligence artificielle ou pour arrêter l'usage de cette intelligence artificielle. Et donc l'intervention est une intervention qui se situe plutôt sur le plan des politiques internes, des chartes internes, et relativement peu dans l'anticipation de la mise en œuvre de ces systèmes d'intelligence artificielle.
Just to add a short comment on that, I think that it's a gradual process. For example, we start with the translation or the transcription tools, and we are not yet there to use AI to draft a whole legal document for a client. So it's still an early stage for us, and we are heavily checking what's going on with the translation, for example, and we hope that going each step along with the client and explaining the process to them and allowing them to understand the connotations of using AI in their own work, and as they start deploying their own systems or finding what fits for them, I think we can progress in the end.
En Grèce, dans le cabinet où exerce Nikos, pour l'instant, ils en sont plutôt à utiliser l'intelligence artificielle pour des besoins de traduction. Ils n'ont pas encore été jusqu'à déployer les systèmes d'intelligence artificielle pour, par exemple, la rédaction de contrats ou pour des travaux de consulting plus élaborés. Donc, on avance à pas beaucoup plus comptés pour ce qui est en tout cas du cabinet de Nikos. I have a question. If AI, the AI world is a paradise, if everything can be done automatically, what are you doing now? Puisque l'IA c'est le paradis, que tout peut se faire automatiquement, vous faites quoi maintenant?
Just want to know about our hobbies, Frédéric. But yeah, no, I'm joking. I'll go ahead. So I feel a bit more like I use the analogy of being the conductor of the orchestra, or I'm like the air traffic controller, right? I mean, sometimes I'm sitting there prompting ChatGPT so much that I hit the usage limits, and then it's either jump across to Claude, which doesn't work exactly the same way, and it's not going to produce exactly the same results I want, or Gemini, which is better for internet research, and that's typically what I use it for. Or you can go to lunch and wait for ChatGPT to refresh your usage limits and things like that. So yeah, I spend a lot of time working on my prompts. I have a document I call my kind of my prompt library, essentially. It's my selection of tools, and I will refine that and things like that. And with the development of even more advanced AI tools, I mean, ChatGPT 0.1 preview is amazing. It's essentially an AI agent that reprompts itself, and you typically get much better results. But my criticism of the more primitive models is you'll give it a complex prompt and say it had 10 points in it, it'll address 6 out of the 10, right? 0.1 can address everything, but it will do what you tell it to. So you need to make sure you tell it the right thing. So I'll often and you've only got 25 goes at that a week. So I'll typically use it when I need to, but I'll spend a lot of time preparing my prompts and things. So I can't remember who said, I spend twice as long sharpening my axe as I do cutting the wood, but I'm sharpening my axe. That's what I'm doing when I'm not using the AIs.
David se considère comme un chef d'orchestre, un contrôleur aérien qui utilise l'intelligence artificielle pour améliorer les usages. Il travaille beaucoup sur ses prompts, il travaille beaucoup sur ses invites pour les améliorer. Il compare également les fonctionnalités des différents systèmes d'intelligence artificielle. Il ne les utilise pas tous pour les mêmes usages. Et c'est principalement à ça qu'il consacre une grande partie de son temps désormais.
One of the other observations you can make is that if you look at what is the role of a senior lawyer, there are many facets to that. AI helps with some of them, but it doesn't help with others. So it's a question of identifying what, in terms of the role that you perform, what are the things that the machine does better? And you work with the machine for that, and you supervise it, and you get the right things out of it. But if you look at the things that a machine doesn't do well, those are the things that you spend more time with. And that can be things like client relationships, higher level thinking, some strategy in respect of practice development, of where your clients are going in terms of their practices. Those kinds of things are not necessarily things that require human connection is not something that a machine is good with. And that is something that can become your hobby.
Pour un juriste confirmé, évidemment, les choses qu'apporte l'intelligence artificielle sont principalement liées au fait que, bien sûr, certaines fonctions peuvent être automatisées, peuvent être confiées à une intelligence artificielle, mais pas toutes. Et il y a des choses qu'on continue à faire parce que nous sommes des êtres humains. Gérer la relation avec un client, c'est difficile de confier ça, par exemple, à une intelligence artificielle. Ça ressort quand même de la relation humaine. Et ça nécessite évidemment d'y consacrer du temps, et peut-être que l'usage de l'intelligence artificielle permet effectivement de dégager un temps qu'on n'avait pas pour cultiver ce genre d'opération, ce genre de posture, tout en confiant effectivement à l'intelligence artificielle ce qui est répétitif. Well, thank you. Sorry, Nikos, we are running out of time. So thank you very much. Oh, you want just one question in French and in English? Quick.
Thank you very much. Pour les gens expérimentés, l'usage de l'IA et ce qu'on peut en faire, je suis OK là-dessus. Ma question, c'est comment on fait pour s'assurer que les juniors, les non-experienced lawyers, acquièrent les hard skills legal. So my question, I'm fine with experienced lawyers and I understand the point of using AI and how you manage your time, which is saved and so on. My question, as an experienced lawyer, as a manager for the transmission of the legal knowledge to the new generation, how do you, as a manager, ensure that you train the junior with a hard legal skill? How do they acquire the hard legal skill using the AI? Sorry.
In fact, it's a question of change management. How are you driving change management for junior lawyers?
Yes. Well, I think that junior lawyers will start to be acquainted with these technologies since early in their career. So for the time being, there are legal professionals that are starting to use AI later in their careers. So for the new junior associates, for the new trainees, they will already be familiar with law from their universities. So when they enter into a law firm, it will be a manager's obligation to gain from their experience in the tech aspects and also guide them through the legal procedures. So I think that having junior associates reading a ton of documents and preparing a handwritten report will not help them in ameliorating their legal skills, for example.
I just wanted to check my understanding of your question, Emmanuel. So was it more along the lines of, in a world of generative AI, how do we make sure we're giving hard legal skills to new lawyers? Yeah, okay. And my mother and my sister are both school teachers, right? And I know from that environment, the maths teacher, the calculator is the bane of the maths teacher's existence, right? Why do I need to learn maths? I've got a calculator, right? Well, it's fine. I want you to use the calculator, but I want you to show me you're working. So for me, that's how I work with junior lawyers in AI, and that's how I work with myself as well. I don't care what results you got from the AI, I care how you got it. So I want to see what prompts you gave it, what results, how you tweaked those results, and then I want to see your critique of the AI. And maybe use another AI to critique your AI, but you're complicit, you're involved somehow, and that's how I handle it. Yep.
Résumé, c'est pas tellement une question du résultat. Le résultat, c'est pas ce qui importe. C'est la manière d'atteindre le résultat. Et c'est de cette façon-là qu'en tout cas David considère que la formation des jeunes doit se faire. Montre-moi tes prompts, montre-moi tes invites. Je vais t'aider à les améliorer, je vais t'aider à optimiser tes invites. Après tout, le résultat, on s'en fiche. Ce qu'il faut, c'est que tu saches utiliser l'outil. Et c'est finalement ce que fait un instituteur avec ses élèves. c'est enseigner une méthode plutôt que d'atteindre un résultat. Thank you very much. Danny, Miklos, please.
Who's doing the slide?
Hi guys. So before we get started, what I wanted to say is that our job is the hardest for two reasons. First, we're just before the lunch. Second, in a tech-savvy environment where everybody is super enthusiastic about AI, our job is to tell you that, just hold your horses. And what I say is that hold indeed your horses. So just be cautious. I think we have said so many things which is just a little bit outlandish, and the expectations are not necessarily in line with the reality. So over to you, Danny.
Thank you, Miklos. That's Miklos from Lexing, Hungary. Donc, je suis Danny Priske, le cofondateur de Lexing au Royaume-Uni, le cabinet Priske & Co. C'est un cabinet reconnu comme un spécialiste de premier rang en technologie, télécom et médias. Ainsi comme les autres membres du réseau Lexing, on possède une excellence en droit numérique, droit de données personnelles, droit d'informatique. En fait, on a aussi d'expertise en droit de la concurrence en matière de données. Donc, excusez-moi, mais je vais continuer en anglais, mais vous pourrez me poser des questions en français. Now, the good news for the English speakers in the audience is that I'm going to switch to English, and that is probably even better news for the French speakers after that intro in French. Now, as Miklos said, the previous panel had the benefit of talking about the joys of AI, and we're now turning to the potential dark side. It's a bit of so we're going to focus on four main areas in terms of the dark side: impacts on society, ethical concerns, legal issues, and technical challenges. So I think in terms of the ethical side, societal change, today, as most of you know, it's the US election day, and with the candidates being neck and neck, it could well be that AI will swing the result today. And the election swing, if it is swung by AI, could literally mean life and death for many people across the globe. And we're not talking just Ukraine, Russia, the Middle East, but even US and elsewhere. So the thought that it could be AI-driven is somewhat concerning. But I would say to that, I did type in today, who will be, and the first thing that came up, I just typed in who will be, the prompt was a better president. It just knew that that is what's being typed in. So everyone is writing, a lot of people are writing, who will be a better president. And I tried it in a number of the main platforms, and I have to say I was very impressed that it was balanced. So far, we're fortunate on the generative AI side that the conclusions were very, very well balanced. But does not mean it will continue to be balanced. And we have to understand that these main platforms are going to be dominating the agenda throughout the world, because especially, I think people English-speaking countries native will be using probably generative AI, or IA in French, to really produce documentation and answers in English. So the influence of the Silicon Valley powerhouses should not be underestimated. I think in these elections, I think AI rather than generative AI could be the ones that make the difference. In fact, I personally believe that Europe has suffered badly from AI-generated bots. On the Brexit vote, David Cameron, the Prime Minister of the UK, was very confident that the UK would vote to remain. And I know that. They didn't use the marketing campaign. They had marketing campaign ready. They thought, no, we're going to win this vote. We're going to remain in the EU. What he hadn't anticipated, and there's no concrete proof, but it seems that Russian AI bots and use of social media, Cambridge Analytica getting into everything swung the vote at the last moment. And Europe is weaker, UK is weaker. We're divided both, financially, suffering the consequences, and I think in many ways Europe is weaker and Russia has gained strength by a slightly weaker Europe. That's my view, and I'm fairly convinced that AI, albeit not generative AI, played a part in that. When it's that close, it can really, really make a difference, and that should not be underestimated. In the UK, because David Cameron resigned gracefully and the people who took over were pro-Brexit, I don't think anyone delved deeply enough into looking into that. But the fact is, those people who lost will have that fear that it swayed the result, and Europe is suffering the consequence. In the US, who knows, what will happen if, certainly if, well, I don't want to say too much, but I think if, shall we say, if Trump loses, I think there will be certain accusations, but we'll get onto that later. But anyway, that's just the introduction and the power of the dark side. The other impact, I think, on society will be obviously loss of jobs. And yesterday, amongst the Lexing network internal meeting, we saw a chart from someone who's providing AI training, and Lexing will actually be joint venturing with this company to provide some really sophisticated AI training and certification to clients. But they showed that they expected that within the next 10 years, 73%, or shall I say over 70% of legal jobs will be lost. So, that is quite a staggering number. I've already seen it. One of our Lexing Baltic members told me they had got rid of all associates in their law firm. They just use generative AI and the partners. And, I think that trend, other partners I've spoken to in different countries have said they're reducing the number of lawyers, and they see generative AI as another associate in their team. It has started. Now, whether you consider the loss of so many legal jobs as something that should be in our talk about the disadvantages, or should have been in the previous talk about the advantages, is very much a personal matter of opinion, but it is very much a shift, and there are going to be many other professions, as we know, that will suffer. So we need to be, as lawyers, very much aware of that. Personally, I think, as mentioned, it will be, generative AI is going to be huge benefit to those lawyers in countries that aren't native English, because I think it's going to speed up their ability to produce contracts and advice in English tremendously, which will also be good for the clients. One thing, though, to say, is on the cultural aspect, and sorry, I'm not quite following the order of the slides, but the slides will be there for takeaway, is the cultural impact. As an English lawyer, English person, I'm seeing already my teenage daughters are speaking in US English from TikTok, and it is slightly disconcerting as more and more with generative AI, being very much Silicon Valley based, that people around the world will become more and more used to the US style drafting, and the English idiosyncrasies are going to disappear, because even people in England are going to start using, well, they are using generative AI, and that's US, and people can't be bothered to go around and what we call anglicize. So slowly there is going to be a cultural shift, and that's going to be across the countries, and just shows the power and the influence that really will be coming from the West Coast. And we are dependent on them really being balanced with their views. We've seen so far, I think they are. But there will be a question of regulation. But I think one point for you guys to mention to you, when you are putting your prompts, consider whether you want the answer in UK English or US English, especially when it comes to contracts. It's a very different style. I'm looking at Lexing US here. The US style contracts are very different, but think very carefully and do say, do I want it in UK English style or US? So if you want, pages in bold cap, exclusions of liability, which are page long, then definitely go for the US style. But if you want contracts which you can read and understand, I would certainly decide the English style, but that's just my personal perspective. But clearly for the legal profession, we are going to have to stay ahead of the curve, and we're going to have to be super bright. We're going to have to outsmart Chat GPT, know how to use it, and make sure we are in control of it rather than actually being overtaken and made redundant. Now, what that means for us as partners in the Lexing firms and other law firms is we have to recruit the best talent, because you're going to have to be super smart as a lawyer to stay relevant, provide value. We are going to have to provide value to our clients. We have to assume our clients will be using generative AI for their contracts. We need to provide added value beyond. So you've got to be super smart to do that. And bizarrely enough, it means we are relying on universities to detect the use of ChatGPT by their students. Our firm, we have a super emphasis on recruiting people with the top academics, just because in technology, telecoms, media, it shifts so quickly, and you need people who can be smart and adapt, like in Lexing Network. Back in 2014, thanks to Alain Bensoussan's vision, we started writing about robot law books. We drafted, we wrote, authored the first book on robot law back then, ahead of the curve. You've got to be super bright when you've got no material. We're the first ahead of the curve. The first, robot I met was in Alain Bensoussan's office. We now hold meetings in the metaverse. You've got to have the people who are super bright. And literally, I am reliant on the universities to make sure that they detect those people who are relying on ChatGPT, etc. So let's hope that continues. And but and especially as I say, going forward, there are going to be less junior jobs open. I think we mentioned that to our Lexing Bolton. So we've got to make sure that those jobs that are there are really taken by the brightest people, and we have to be aware of when we're recruiting people to make sure. At the same time, it's a balance because we also need lawyers who can use generative AI properly as well. So it is a balance, but if we want to stay relevant to our clients, provide value added, we've just got to make sure that we are recruiting the best talent. And sorry to re-emphasize that. I mean, on that note, it's quite interesting. My son, this is just an aside, my son class, he has a laptop in his high school, and when he gets set homework, he's done it on ChatGPT by the end of the class. Now, it's a bit disconcerting, but that's just, you know, that is what's happening now in the school, so we have to be aware of that. Now, I'd like to think he tells me that he does the boring, mundane homework on that, and then the homework that requires his real thought and education, he does properly. I hope he's right, but we just have to be aware that there is a generation who are using it now at school, for better or for worse, but we have to be aware of it. Otherwise, on a couple of points, deep fakes, which are going to be increasingly problematic. So I'm just going back. They are really horrific. When you see these videos of people speaking using different words, it really is scary. And I mean, so we've got to be very, very aware. We don't know what will happen after the US elections are coming back to it. It's a big day, but we may see deep fake videos. And one tip I was told is make sure on your voicemails, you don't have them personalized. Go back to the standard, because apparently those personalized voicemails can be used to clone your voice to create deep fake videos. So just that's the sort of society we are living in now. And then before I hand over to Miklos, just one tip in terms of coming back to generative AI. And this, I could go on forever, enough rambling, but on NDA, so when you're acting for companies that are looking to raise money or sell, you know, you're putting your confidential information into a virtual data room. We're not doing the physical folders that our Lexing Hong Kong member mentioned back in the day of the due diligence process, those big lever arch folders in dark, dingy rooms, which I'm old enough to remember myself. I would suggest in your NDAs state expressly that the data is not to be uploaded into any large language modules, LLMs. It could be personalized, because if you're a company, you're putting your confidential information out there, that NDA should be watertight, and it should mention that it's not to be uploaded. If you're acting for the selling company or the company, we can put it in your NDAs. It could be implicit, but you never want to bring an argument on an implied term. It's much better to have a contractual term. So I think that's one tangible tip to think about NDAs, because, you know, they are being uploaded into generative AI, and it's very, very important. It just doesn't go out there. So on those concrete tips, after a lot of talk about some of the dark side, I will let Miklos continue with other aspects of the dark side.
Yes, indeed. Thank you, Danny. Thank you. Yeah, thank you very much. Thanks, Danny. I'll try to talk about some of the things. To start off, I know that there's going to be a session dedicated on IP, but I'm not going to cover that. There are some obvious problems with AI, especially because these large language models have been trained on vast amount of information crawled from the internet. And it is very probable that there will be court decisions ruling for copyright owners. There are some already, which can mean it's going to cost you even more to build a new model. From an investment perspective, whoever could build a model so far invested around $100 million. That's around the cost of a large language model. Some say it's a little bit less. Some say it's actually, for OpenAI, it could have cost 3 times or 4 times more. Just the first model. We talk about the version 3, which came out on November the 30th, 2022. It must have cost them around $300,000, according to some insiders. Officially, it's 100. Look, they haven't paid a dime to any of the copyright owners. You know this very well. What's going to happen if you have to pay? Building a model is going to cost you even more. It's going to cost you maybe $1 billion. What will it mean in terms of economy? That in this industry is at best an oligopoly. Oh, I can't really pronounce that word. Anyways, it's a market with a few players, and it's a very concentrated market. It's already a very concentrated market. If you look around how many good LLMs are there, which are easily usable, you don't need too much, GPU power in terms of, graphic processing unit power to use. There are only a handful, maybe 5 to 10. There are 10,000 available, but those ones you can actually use for your everyday work, maybe in the size of, in the size of 10, a little bit less than 10. So we're talking about the concentrated market. And, there are certain layers in the AI game. So you have an LLM, which is like an engine in a car, but you want to make it custom-made for your needs, right? This is what you want. You just don't want to have a chat with a GPT, but you want to use it for your own firm. In order to do it, there are various ways to do it. You have to fine-tune it. If you want to fine-tune it, then it's going to cost you. So it's going to cost you some money. But you are already very dependent on that very model we're talking about. So it is creating a platform economy by making sure that you're hooked onto their model. Because building your own LLM would cost you, if the copyright owners will be allowed to, they will be entitled for their royalties, then it may cost you $1 billion. If it's not, then we're talking about between $100 to $300 million. It's not going to be an option for most of us. So we will be dependent on these big models, a few of them. In fact, the latest round of investment for OpenAI was $6.5 billion. So it is getting even more concentrated. What it means? It means there is an antitrust problem here. It's a platform economy where you are dependent on a few players. Whatever you do, you end up using one of them. And in an environment where there are only a few of them, they can raise prices easily. And you're dependent, so you don't really have a choice. So there is a market concentration problem, which is very obvious. Not to mention the other is that in this market, the gap between those people who actually understand how these AIs work and who understand what the offering is, and those people who are the actual users, is staggering. It's just staggering. The gap is staggering. You don't even know what you sign up for. You sign up to. If you have already tried OpenAI, ChatGPT, or Copilot with Microsoft, have you ever checked the terms of use? And it's not about being a lawyer. It's more about what you sign up for. You don't really have a choice, like I said, because it's a concentrated market. You don't have too many options. They're going to follow suit, so most of these players going to have the same terms of use. But the other problem, which is very obvious by now, is the average user is not on the level of understanding what he or she is signing up to. Because no one knows how these models work on an everyday basis, and that's a real problem in terms of consumer protection. It's not about, I don't know. You may not understand too much about finance, but you still understand the basics of an insurance policy. Same applies to mortgages. Same applies to you buying a computer. There are certain metrics and so on and so forth. What do you understand about neural networks. Unless you are qualified and you're really good in certain parts of mathematics, most of the consumers who are using it on an everyday basis have no clue what is going on, behind the curtain or under the trunk, whatever we say it. So this is a huge competition/antitrust problem what we're facing with regard to these large language models. In addition, yes, we have the IP, which is going to be covered later this afternoon. But obviously, there is the question, these models need huge amount of information, large quantity of documents. The big question is it fair use to use them for training? And with regards to the output, what happens if something is produced by an AI? Whose material it is? Is it yours who prompted it? Is it the AI producers, the AI operators, or somebody else's? If we use the old-fashioned kind of IP way of thinking, which dates back to the 18th century, we just say, it's not human, you gotta be a human. And unless you're a human, you can be a copyright owner. But that's like, it's 200 years old kind of thinking. We don't know the answer, but there are some very obvious problems with the IP aspects of this. But what I really want to talk about is more on the side, not on antitrust and not even on IP, but the technical challenges what we're facing as lawyers. And there are some really big ones. To start off with, if you take a photo, I made a typo and sorry about that. The legalese is with 2 E and not with an I and an E. But just for the sake of, otherwise, I can write well. So what I wanted to say is that these models don't understand the legal language. Legal language is a language. It's like, it's a special code. If you have to compare it with something, I would compare it with a foreign language. But when you make a translation from one language to another, it's really easy for a model to do the same thing. What they do is they each and every word is represented in the multi-dimensional space. And what they try to do is how far is, in this multi-dimensional space, how far is kitty from cat? And it doesn't really matter that we speak Zulu or English, because it's the same logic we're trying to follow here. However, if you try to find this kind of closeness, this remoteness of closeness, these connections in an artificial technical language like legalese, which is the legal language, it is really hard to represent. So one thing that is a challenge already is how you represent legal language. And I'm in the middle of building a model, and one of the biggest challenge was how we can train a model to understand legal language. And we had to basically reopen the large language model and rearrange the weights in the neural network in order for the model to understand legal language. Otherwise, it makes certain mistakes, because if you use words like agreement, damage, loss, and things like this, which has a meaning in the plain language as well as in legalese, it may distract and follow the line of the plain language rather than the technical language, and therefore it's going to start hallucinating. So it's one thing that it's really understand for you guys, lawyers practicing, whenever you use an AI, the generic model does not understand your technical language. You have to be super careful about it. And, legal is a really small business. It's less than 1% of the global economy, much less than 1% actually. It's estimated to be around $1,000 billion, but it's nothing in comparison with other industries. So if you are an AI developer, the legal market is not that important. So until they're going to train a model on legal language, you can wait a while. There are some industries which are much, closer to kind of closer to their focus than legal. So we have to solve it ourselves, for the time being at least. Number two, and that's, I think, the most important thing. If you remember one thing from this presentation, what we make, remember this. Large language models do not know a thing. Their goal is, the way they have been trained, is to maintain a conversation. And they're really good in that. They can maintain any kind of conversation. And that's important for you to understand. Their goal, every code has a goal. If you ever coded, you know this. If you haven't coded, trust me, that's the whole essence of building a model, building a software, because a model is a software. So as a software, it has a goal. The goal is to maintain the conversation. Its goal is not, it's not a Wikipedia, so it's not going to know the law, it's not going to know what you're asking. If it knows, it's only a side effect. You have to combine it with a knowledge base if you really want to make sure that it's not going to hallucinate. Knowledge base is everything. The upcoming 5 to 10 years are going to be about combining these, chatty machines with the ability to know something. And that's a different thing. The combination of these models with knowledge bases is the key if you really want to use for legal purposes any of these models. And how to build, the best knowledge base that is understandable for an LLM, that's a really hard one. I've been researching this for 1.5 years. It's not an easy one. No one knows the answer. We have some rough ideas. But one thing is absolutely certain, that, the more is better kind of argument is not true. You have to be structured in a sense, computationally structured, not humanly structured. And how a computer thinks and how you think is completely two different things. So one thing I can guarantee is the real challenge, the disadvantage of using AI for legal things. These things are not made for lawyers. These things are not made for doing legal things. You can make it, capable of doing it, but it's a tough thing. Prompt engineering is not going to be enough. You have to do a couple of things. First, fine-tuning. Second, combining with knowledge bases. And you can give your knowledge base by giving, a very good, extensive prompt. That's one way of doing it. Or you combine it with your own knowledge base is another. There is a technique called RAG, which is retrieval augmented generation. But that's one way of combining an LLM with the knowledge base. Unfortunately, it's anything but perfect. And last two things I just want to mention before we wrap up. The first is that these statistical models are prone to hallucination. We all know that. It's like, I think it's common knowledge by now. And when I say it's prone to hallucination, basically it means you'll never be able to solve that problem. It just means that you may minimize hallucination to, let's say, to 3%, but to 100 it's impossible, because the model itself, as it stands at this very moment, is a statistical one. So at best, it can give you the right answer, or what you expect to be the right answer, let's say to 95 to 97%, then that's not 100. And it will never be 100. This is statistics. It's different. It just gives you the most probable next word in a given sentence, in a given context. It's not the right answer. Because if you want to have a Wikipedia which gives you the right answer, forget about statistical models. So what I want to say, again, bear in mind, it still requires some sort of supervision, either by humans or build another model which is going to do that. But somehow you have to keep this in mind. So
And garbage in and garbage out, again, is something you heard many, many times. If you train any model, the problems, the garbages of your training model will be replicated in the outcome, obviously. So if it's biased already, then your outcome is going to be biased. If it's not perfect, your outcome is going to be imperfect. So it's all about how you build a perfect training data set. And how you build a perfect training data set, how you build a perfect pool for a poll. No one knows. I mean, look around, general elections all around, they all failed. It's a statistical challenge, which no one understands. How you can build the perfect representation of a society. Yeah, there are some really good professional guesses, but no one actually knows. And at best, you can be 95% sure about something. And this is why all of these models are imperfect. Because you can't have a perfect data set for law. It's going to be, by nature, imperfect. So, in a nutshell, I've been dedicating most of my time in the last 5 years to AI and legal tech. So I am, as a human being, is very enthusiastic and also dedicated to legal tech and AI. But based on my experience, what I can say is that don't get super excited. Be realistic.
Thank you very much, Miklos. And I think Alain would add, the less experienced you are, the most impressed you will be. Because if you garbage in, garbage out, it's exactly that. So you should be very precautious when using AI tools. And when I'm listening to you, I think we should run rather than use AI. So I was very enthusiastic when I was listening to David, to Miklos, to Nikos and to Patrick. But now I'm not sure of that. And what I suggest is that we talk about this during our lunch. Donc je suggère que nous parlions de tout ça pendant le déjeuner. Quelques points d'organisation, si vous me donnez encore 2 petites minutes. Les membres du réseau vont rester ici quelques minutes pour faire une photo de groupe, pendant que vous serez accompagnés vers le restaurant qui nous accueille par Marilyn, qui est en train de se préparer, je la vois, voilà. Et elle va donc vous accompagner tranquillement au restaurant et nous vous rejoignons dans 5 petites minutes. For the Lexing member, please stay here. We will make a photo here. And we will join our guests just afterwards, and Marilyn will conduct them to the restaurant. Thank you. À tout à l'heure. Merci beaucoup.